Have your lordship's kind leave to mention, my lord, Group 8 assigned matter, my lord. My lord,
Group 8 assigned?
Group 8 assigned matter, my lord.
When was it assigned?
My long back, my lord. It is not in the list, my lord. My lord, similar matter, my lord, has been disposed of by the regular bench, my lord.
All right.
So, my lord, if your lordship, my lord, your lordship is
Give the number.
my lord. Let the matter appears to be mentioned, my lord, tomorrow, my lord.
Not tomorrow. Let the file be brought.
My lord.
My lord, upgradation, my lord.
Yes. What is the
Let it be
item
listed,
number?
my lord.
1177, my lord.
Combined list into. Take note. Item number?
1177, my lord.
Very well. Serve notice upon the other side.
1131.
1131.
My lord, 919, your lordship.
919.
I have served other side.
Even thereafter, you please serve so that your other side is there at the time of call of the matter. All right.
1179.
919.
1179, my lord.
1179.
1037.
1037.
My lord, 1448.
1448. Serve notice on your other side. 1545.
1232, my lord.
Only one.
My lord, 855.
855.
My lord,
1662.
1376.
1376.
1342.
Yes.
144.
Lordship.
144.
Item number 144.
144.
Yes.
It will be taken up immediately. Why are you mentioning?
Lordship, inclusion. Inclusion.
For upgradation.
Inclusion, we have taken up a lot of slips. No further inclusion. These are the matters which are there in the list.
For inclusion. Contempt application.
You have to wait.
My lord,
1167.
My lord, 737.
Why did you not mention it yesterday?
Yesterday.
Yes, what is it?
Proceeding has been initiated. But for removal of another structure, my specific case, it is my land.
Where is the matter?
1023.
Who is your other side? Enquire. 1023. All right.
I am.
My lord, 737.
737.
Is for upgradation 1372. 1372.
Yes.
789.
789. Yes. 1532.
Lordship, 760 praying for upgradation. Lordship. 760.
760. Serve notice. 749. Yes.
Lordship, matter will be
Non-prosecution contempt matter of Circuit Bench of Jalpaiguri, my lord.
Non-prosecution of a contempt matter. Circuit Bench of Jalpaiguri. Give the number.
Lordship, matter for
1129 non-prosecution. All right.
contempt application
981, your lordship. 981. 981.
Sorry. Today only the lady members. Otherwise, no.
I am.
There was a lot of rush.
I am praying for relief. Extreme urgent matter. I have got this matter on Sunday. I could not take this leave yesterday. The extreme urgent. My visa will be cancelled. I am a job worker in Dubai. I have taken 2 months leave for renewal of my passport. I came to India. What happened, my lord?
What? Take leave. It will appear on Thursday. Serve notice.
My
I'm paying for 1125.
1125. No further.
Filing contempt application file in June, month of June.
Then please wait.
My lord, may I pray for leave, my lord? My lord, matter relates to election and counter-election.
Off.
My lord, election to a trade union of a postal department has been conducted under the supervision of departmental observer. Now the department is not approving the committee and they are tacitly supporting a counter-election to be held, my lord. That has been scheduled on the 20th. That is the urgency, my lord. That's why the leave. My lord, anytime next week, my lord.
Monday.
Lordship, I'm praying for leave in the
Lordship,
Lordship.
981, your lordship.
Aadhaar card, Lordship. On
981.
the basis of Aadhaar card, they stopped my savings account, Lordship. I'm 70 years old, Lordship. I'm praying for leave only. Can you fix it tomorrow,
Why
Lordship?
leave? You can file it
I
in the
did not take
department.
money from the bank, Lord. They have stopped my savings
I
account.
understand, but then anyway,
I'm 70 years old, Lordship.
next Monday it will appear.
Grateful.
It'll leave the into.
Your lordship, 981 of the monthly list, your lordship. It's a drug license been issued against my permission as a landowner, your lordship. 981 of the monthly list.
981. Yes, serve notice.
Yes.
Immediately, my lord, I'm mentioning item number 48 of today's list. My lord,
Right.
kindly hears me for 1 minute.
Ah,
1 minute.
now what has happened?
My daughter has been murdered, my lord.
Yes,
I had filed this writ application in the month of June end,
all right,
giving the date of today. That is,
all right.
it has duly appeared.
Hmm.
My lord, what happens, my lord? Yesterday night at about 9:30, the respondent number 4 being the police authority, my lord, they have went to my house. They wanted to search my son. They could not do so. They have pasted this in the
Notice.
stating that yesterday 9:30 in the night, stating that at 10 in the morning, I have to go before the court, my lord. Only
Before
since
the court?
before the court, since
For
the
what? Which court?
before the
Trial court?
about that, my lord. One thing, since the papers are not with your lordship, my lord, kindly, since this is what I had alleged, page 26. To the,
No, what? It's a photograph I can see.
my lord, my daughter was murdered.
Yes. No, what is to be done by this bench?
My lord,
This is not a police inaction bench.
my lord, what happens? I had initially filed in this bench. Subsequently, my lord, there has been a communication to my learned junior from the department. This matter may go before Justice Tirthankar.
Right. So I'll release it immediately.
Is it, my lord?
Certainly. Item number. For that reason, there was no requirement of mentioning such a lot of history. Which item is it?
Well, 48.
48 released from the list. কোথায় গেল?
Now,
আছে? 48 today. Jana Babu, the file should immediately go before Justice Ghosh. I'll send it immediately.
item 48 likhe amara to naam.
Nothing can be done today.
Your lordship, may I permit mention?
Lordship, I'm
Up
seeking.
for petition 1535 item number.
But you are too late. Only for today I am taking it.
Your Lordship,
1525.
1535.
1535. All right.
I'm seeking leave to file an urgent matter, Your Lordship. Your Lordship, the petitioner is the Your Lordship, the marriage register. Your Lordship, she has been, Your Lordship, restricted to perform her duty by the Registrar General of Marriage, Your Lordship, without any valid ground, Your Lordship.
Right.
That is the urgency, Your Lordship, since Your Lordship, she has taken some assignment to, Your Lordship, register the marriage. So it is supposed to be held today, Your Lordship. Kindly, Your
What?
Lordship. The
Marriage?
Yes, Your Lordship.
Nothing can be done. What will the court do?
So since Your Lordship, she has been restricted by the Registrar General of Marriage to
Yes.
perform her duty.
Right.
And
I
she
cannot
was not
But then the court has to see what is there.
My lord,
kindly, Your Lordship, since
mention item number 769.
For what?
Approached through legal aid. Her husband died due to tiger attack in Sundarbans.
Yes.
She has been seeking compensation
Yes.
and has been denied. Therefore, she has filed through the Legal Aid Society a writ petition. If they will be upgraded, my lord.
Why did you not mention yesterday?
My lord, I tried. I could not. I was.
No, you are not right. The entry of the court was made clear so that the advocates can enter. What you are submitting is absolutely improper.
I really tried, my lord, yesterday.
Yes.
I really tried to mention the matter.
Your submission is not correct. The court
Lordship.
is not accepting, but considering the merit of the matter, the court is it will be put upgraded. What is item number?
769, my lord.
Serve notice upon your other
My
side.
lord, I have informed the other side.
Not only information, your slip is not required. When the matter is taken up, the other side should be
Deeply
there.
obliged.
allow me to file this matter, Your Lordship.
File it. Call the list, please.
Lord, this circuit bench matter will be taken up.
Lordship, in this matter, 2 contempt application was filed. Mainly, my lord, CC number 44 of 2024, wherein your lordship is directed to demolish that is dangerous building and clear out the debris, your lordship can remember. And thereafter, another contempt CC number has been filed in the self-same contempt application, and that is only pending. On previous occasion, your lordship.
Today there is a resolution of the bar.
Today, that is.
Yes, so I'll make it only not today.
Lordship. Lordship. Lordship.
Melody, there is an one matters in circuit bench.
Well, I for the alleged contemptness, my lord. Giving the report, my lord, that order has been acted upon by Rosimal, although there is some delay, of course, my lord. And last occasion, you see, there is in the petition, there are certain defects regarding the names of the alleged contemptor. However, my lord, that
Yes,
My lord, the defects, we have sent a letter to the registrar, my lord, for rectification of the
correction of the defects. Has it been corrected? ঠিক হয়েছে দেখুন তো corrected. All right.
defects.
but usual lawsuit, usual order to deal with the unauthorized construction, dispose of, my lord, that has been disposed of, or the special officer has already passed the order.
Recorded copy of
Is the petitioner aware of it?
No, my lord, I'm giving it to you.
my lord,
Because it has been, my lord, it is in his favor.
No,
The
maybe
order-
in his favor, but then
I'm
I
giving it, my lord, I took it.
have a copy.
My lord. Those things are not to be looked into, the other interim order, the final order that immediate after the report. That is the
30th
final
of
order.
May. 30th May. Go through it and come back.
yes, my lord.
Please come. Learned advocate representing the contemptor submits upon instruction that the order of the court has been complied with. Stop. Certain documents have been handed over in court, along with a report of the executive engineer within bracket C/building/borough XII dated 30th June 2025. Comma, the same is written with the records.
And also the order of the
Stop
special,
করে দিয়ে
and
দেবো.
also
The
the
same
order
is
of the
written
special
with
officer
the records. The order of the special officer building dated
28 June 2025. It is immediate after the report, you will also look at immediate after the report.
28th June 28 June 2025 filed in court is written with the record. Stop copy of the same has been handed over to the learned advocate for the petitioner. Tomorrow, day after.
On the day after, my lord.
All right, let's day after tomorrow.
Well, let it be on Friday morning.
My lord,
Friday.
Mrs. Choma Mukherjee is appearing online.
Friday.
I'm appearing online.
On behalf of the petitioner, I'm praying for not today, my lord.
My lord, Mrs.
Lordship,
Choma
there's one-
Mukherjee is online.
Lordship, there's
Yes.
one thing, they have served the exception to the report on the 2nd. They were supposed to serve it on the 30th. They've served it on the 2nd. Your Lordship would give us a fortnight's time to reply to the same.
Exception has been given to your report.
To our report, Your
Correct.
Lordship, report drawn up by the ICC, the Internal
Alright.
Complaints Committee.
All right.
My lord, I appear for respondent number 6. I am the MD of the
A copy
company.
of the exception. Is it filed in the department or what?
I think, my lord, it's filed
Filed
in
in
the
the
department.
My lord, this has not been served
Under,
upon us.
under whose back sheet will it be?
Obratanu Sarkar.
Obratanu Sarkar.
দেখুন তো আছে আছে
Yes, sir.
Is this the one?
Yes, yes.
No, but this is a supplementary affidavit on behalf of the petitioner. Where is the report? You are for? Who are you representing, madam?
My respondent 6. I am the MD of the company. I'm not
Copy
part of the
has not
committee,
been
but it's not been served, so we are not aware of anything.
No, that is, my lord, exception to the report filed by the committee, but it's
Oh,
how?
committee.
Correct.
Yes.
All
My
right.
lord, so we have no
They
statement.
have not used any affidavit, my lord. Well, can I take it tomorrow? I shall find out where
Your
it is filed in the department or no.
learned senior friend for the respondent numbers 1 to 5 seeks time to file an exception to the report.
Exception to
Lordship,
the
not the report has been filed by us. They have filed an exception.
Then what else will you
What?
file?
Yes.
Lordship, we want to deal with the exception that they have filed.
Well, since, my lord, your lordship passed an injunction
It
on
is better I make it only not today. Let it come up in the list tomorrow.
tomorrow.
We'll see whether any further direction is required to be given or not. Only not today.
Right, Lordship.
This is my application, my lord.
Yes, he's your other side here.
This state was being represented by on the last occasion by
Tonoy Chakraborty's name I can see.
Tonai Chakraborty. The lordship may recollect that this is the matter relating to, my lord, release of incentives. For the prior period, there is already an order passed by a coordinate bench, my lord. So, my lord, for this period, my lord, we have taken out this writ petition. Subsequent period.
What to do? Your other side is not here today.
Very well.
I'll make it only not today.
No,
It will remain in
May
the
I
list.
just let it retain its position in the list?
It will be there in the list. Let us see what happens
But because,
tomorrow.
my lord, I tell you, Rashi, what they will come and say. For the prior period, the judgment has been delivered by the coordinate bench. That judgment has been carried to the division bench by an intercourt appeal.
All right.
That intercourt appeal is supposed to appear tomorrow.
All right. So I adjourn it for till the next week.
It is already recorded in your lordship's earlier order. So, my lord, I beseech your lordship, kindly keep it on Monday or Tuesday or better round.
Next week.
Tuesday, my lord.
None represents the respondents. Staff release the matter for further consideration on
Tuesday,
15th.
15th, my lord, 15th.
I briefly appear for the respondent bank, my lord.
Lordship, I am appearing on behalf of petitioner, your lordship.
Of
I
the
am praying.
petitioner?
I am praying for not today, your lordship.
My lord, kindly see.
The arguing
the
counsel
equity-
is not there.
Presiding officer of the DRT, DRT all are made party.
Yes. They are necessary party to this proceeding.
Then send-
Lordship, I am
present-
praying for
send to
not
my
today.
colleague, but-
Your lordship, my senior is there. He will satisfy on
Only not today.
not today.
Kindly, my lord, certain disputed question of fact is even may I, my lord, come with a very short affidavit.
No, tomorrow. Let this make the same prayer. Renew your prayer tomorrow.
Much obliged, much obliged.
I'm for the petitioner, your lordship. Your lordship, service has been refused by the respondent number 2. Your lordship, may I handle?
Who is the respondent number 2?
Your lordship, regional passport authority, your lordship. And it has been effected on the respondent number 1.
Behrampur, Murshidabad.
He has refused, your lordship. May I hand over the postal envelope?
Did respondent number 1 accept?
Your lordship.
It has been accepted.
Your lordship, that has not come.
I'll take up the matter tomorrow. All right. I'll only make it not today.
Grateful, your lordship.
Yes, call the next matter.
Item number 7, my lord, that matter, my lord, which has been heard by your ladyship. The last occasion, my lord, Mr. Kaur, my lord, concluded his argument, my lord. Now, my lord, the learned advocate general is appearing, my lord. He is to make the submissions, my lord.
Yes. Nobody is there. Mr. Sen.
Same was also.
I was expecting the learned advocate general to be here because that he is leading me. Maybe that he may have got stuck somewhere. But kindly keep it any other day.
I'll make it only
Here I
not
will
today.
start it.
I'll make it only not today.
Lord, kindly give leave tomorrow, not any after day after tomorrow, Lord. But in case, Lord, he doesn't come, I'll start, Lord.
He will certainly come. It's not that he won't come.
No, no,
Maybe
he may
possibly
have
for
stuck
the yes, for the
He may have got
weather, he
stuck
may have got stuck. So I'll only make it not today. Let it remain and
Very
retain its position in the list.
Grateful.
Thereafter, if you want to make any prayer, renew your prayer tomorrow.
Grateful.
For the petitioner, my lord, Mr. Bachawat is leading me, my lord.
Couldn't reach. Only not today in that case. Not today.
Even to 13,
Contempt petition, my lord.
the writ petitioner is not here, but I'm submitting that there is a direction the lordship will be agreed to hear both the writ petition which has been assigned
And the contempt.
and the contempt, two contempt matters. There is a direction the lordship gave it, my lord, for filing evidence to the writ petition. My landman possibly has filed.
No, I have not filed in opposition because all the things are already on record in the
But, my lord,
contempt petition and
at the end, my lord, I have thought, my lord, that to file an affidavit, my lord.
To what?
To the writ petition.
All right.
It has been prepared by me, my lord. It has not been affirmed. Your lordship kindly adjourn this for 7 days, my lord.
All right.
All these matters, my lord, then I could, my lord, file the affidavit in opposition.
You are for the corporation?
Yes, my lord.
All right. But then possibly an appeal or something was.
No, my lord. No.
Here, no.
Nothing is there right now. All things have gone, my lord.
All right.
Now, my lord, ultimately the matter went before the single bench regarding the writ matter.
All right.
Having regard to your lordship's directions in the contempt matter, then the court, my lord, released the matter. Then it has been assigned to your lordship's court.
When Lordship has been hearing this matter, their contempt application is also there. Our writ petition is also
The
before. Lordship.
corporation seeks time to file opposition in the writ petition.
Very well, my lord. Very well.
Right?
Very well.
Please come.
কতদিন?
Learned advocate representing the corporation seeks time to file affidavit in opposition to the writ petition.
এটা কি আমাদের restriction?
In view of such submission, let opposition be prepared and circulated by 18th of July will be all right?
মানে reply maybe, my lord.
Reply within a week?
10 days.
10 days.
10
আচ্ছা ঠিক আছে. Reply within 30th July.
A copy of the
Release.
a copy of the same may be given to me also.
You are for the petitioner in the other writ petition or for
Contempt.
All right.
But in contempt matter, he is the petitioner in one case.
We'll circulate, no problem. No problem. We'll circulate.
Release the matter for further consideration on 12th August.
Deep
Stop.
leverage.
All pleadings shall be exchanged in between the parties.
Deep leverage. Deep leverage.
Give your appearances properly, otherwise somebody's appearance will go against somebody. Nobody knows. Please. Yes. Oh, you could land up.
I'm so sorry, Miller,
It's all right.
but I'm also growing old now.
No, it's not because of your age, because of the weather condition and the road condition.
No, I came early today because I apprehended waterlogging.
Yes. So you started early.
I started early.
What do? Do we start hearing?
But I can start, but I can't
Is your-
finish today.
Is your other side here? Yes, please call. Then we can at least start little bit.
প্রথম রেখে দিয়ে আসছে Now, my lord, here, your lordship has been pleased to, my lord, hear the writ petitioner in extenso, where the prayers primarily are, my lord, in respect of a direction on the legislature by the judiciary, which in my very respectful submission would relate to the affairs of the legislature. I'll put it in a very broad term. It may or may not fall within the proceedings of the legislature, but my lord, it falls within the affairs of the legislature, where the presiding officer is the speaker. Now, this presiding officer is a presiding officer for all purposes. Take an example for the judiciary. My lord, the Honorable the Chief Justice is the head of the administrative side of the High Court, as well as in relation to the judicial functions as well, with some administrative functions at the same time. Therefore, my lord, this discussion had always been after independence as to what extent the judiciary can interfere with the functioning of or with the affairs of the legislature. Now, this is a case, my lord, where my lord would have to decide to what extent the powers of judicial review can be exercised where, my lord, the immunities, privileges that the legislature or the assembly enjoys, my lord, under Article 194 of the Constitution, read with Articles 178 and 212 of the Constitution. With that, we also need to look at Millard 7 schedule, list 2, entry 39. And as your Lordship knows, Millard, under Article 208 of the Constitution, Millard, the state assemblies frame laws or regulation rules for regulating the procedures within of all activities within the legislature or the legislative assembly. Now, the interplay of all these provisions and the power, privileges, immunities which are available with the legislature, Millard, is the subject matter, according to me, of this litigation, whatever may be the prayer. Now, the prayer seems to be somewhat not that important, because the prayer is that to allow the central security forces. Kindly have a look to me at the page number 18, 18 of the writ petition. The prayer B says, issue a writ in the nature of mandamus directing the respondent so and so to immediately allow the central security forces to enter into the assembly house precincts along with their protectives. C is issue writ in the nature of mandamus directing the respondent authorities to ensure protection of opposition MLAs inside the assembly house precincts. Number one thing has not. I'm sorry, Milord, I did not hear the arguments of Mr. Kaur. I do not know whether, Milord, Mr. Kaur has addressed your Lordship on this issue or not. What does the petitioner mean by the expression precincts of the assembly house? Precincts in ordinary English terms would be the surrounding areas.
একটা বই দিয়েছিল না?
Lord, if your Lordship has been
The rules of procedure, this, yes.
kindly similar, page number 2 of that book.
Precincts of the house.
Means and includes the legislative building and the ground surrounding it, enclosed with iron railings. Now, the writ petitioner, Milord, wants, since he's a central security protectee, he wants that his or whatever guards, whatever would be the appropriate term, I do not know, they should be allowed to enter
inside the iron railing premises.
Now, so far as, Milord, the security of, because over inside the legislative assembly, predominantly the people's representative function with the other officers, the departmental staff, etc. Therefore, this is a place where the people's representative are available. They have certain functions, duties in the democratic process, in the legislative process, which are carried on by them. Some of them are considering the threat perception, Millard, people are protected accordingly. Some have Z category, some Z plus, some have central security, the rest are with the state security. Therefore, Millard, first question may arise is whether a central security protectee does stand on a higher footing than the state security activities in or within or beyond or within the precincts of the assembly? Does he stand on a higher footing, or his threat perception is higher than the others in the premises? But we are not concerned about the rest of the world. We are concerned about the place called assembly building and its surroundings. Whether, Millard, his threat perception is higher or more than the other state security protectors. Second is whether, Millard, this can be a subject matter of judicial review or not. I would be very humbly trying to assist your lordship that this cannot be a subject matter of judicial review. Because apart from the constitutional embargo, if I may use this expression, possibly the court does not have the wherewithal to look into this. Now, Millard, may I take your lordship, Millard, through 3 or 4 paragraphs of the writ petition, and then, Millard, how we have dealt with his case in our opposition. Millard, please have a look to paragraph 3 of the writ petition. The cause of action is this. The petitioner states that on 24th of July 2024, at around 12:20 p.m., when the petitioner number 1 was leaving the assembly house from his chamber at the assembly house, when suddenly at the lobby of the assembly building, the petitioner number 1 was attacked and attempted to be assaulted by one so-and-so, who happens to be a member of the Legislative Assembly from so-and-so constituency and from the ruling party. So this appears to be the cause of action. Now, what is a lobby? Please come back to that book once more.
Yes.
So page number 1. Lobby means the covered corridor immediately adjoining the chamber and co-terminus with it. So it is basically a corridor which is
adjoining that,
which runs, Millard, in front of all the chambers that are there in the assembly. Now, please take, Millard, the representation which your lordship would find at page 24. Regretfully, I am to state that today at about 12:20 p.m. at the lower lobby, C. so-and-so rushed towards me and tried to assault me physically, shouting XYZ. That is not very important. Let us not go into that. Therefore, whatever has happened had happened at the lower lobby. Therefore, Millard, this appears to be the reason or a fact which had triggered a so-called apprehension in the mind of the writ petitioner of insecurity, which, according to him, requires that his securities should follow him in the assembly premises. Millard, we have dealt with it in our affidavit in opposition. Now, please take, Millard, our affidavit in opposition. But the legal aspect, but I will skip over for the time being. Please take paragraph 6 of my affidavit in opposition at page 13, 13.
Yes.
With reference to the allegations made in paragraphs 3 and 4 of the writ petition 7 accept so and so, denied dispute, it is denied that any untoward incident had transpired within the premises of the assembly due to any decision of the respondent number 1 to restrict security cover of the petitioners and other opposition MLAs from entering the assembly house compound as alleged thereof. It is further denied that the security provided by the state government to the members of the treasury are allowed free access to any part of the assembly compound as alleged or at all. Insofar as the complaint of 24th July is concerned, the same has been looked into by the Honorable Speaker and was placed before the House for discussion by members. With regard as to whether Sri Tapan Chatterjee allegedly attacked or sought to assault the petition number 1, and whether the said Sri Tapan Chatterjee is a repeat offender or whether Sri so-and-so tried to assault the petition number 1 or other members of the House on the floor of the House on an earlier occasion, the petitioners are put to strict proof thereof. Sri Tapan Chatterjee has not been impleaded as petitioners, impleaded by the petitioners. In the instant proceeding, the petitioners have not provided details, particulars of the allegations, etc. Then, Millard, please take para 7. With reference to para 5, 6, and 7, denied dispute, the security personnel of the petition number 1 had on an earlier occasion been involved in an unsavory incident. This led to prohibition of entry of central security personnel inside the precincts within the Legislative Assembly. Such prohibition took place on and from 6th of May 2021. There has been no allegation with regard to breach of security or apprehension of lack of security of any member of the House at any subsequent point of time except this petition. The security personnel of all MLAs have been provided with waiting space by way of temporary shed at a well demarcated site in between gate number 2 and gate number 3 of the Legislative Assembly. The said site has been earmarked for all security personnel, including the personal security officers of all members, including ministers. No one else except for the writ petitioners and Sri Mihir Goswami has ever expressed any dissatisfaction or complaint with regard to the same. The CISF CRPF personnel who may be acting as security staff of individual members are not required and or not permitted entry within the precincts of the assembly. The said personnel have also not complained regarding their waiting space. There is no dearth of proper shed at the site where the security personnel of individual members and ministers wait for such member ministers. The Legislative Assembly cannot be compelled to permit any number of individual security personnel of the members of the House entry into or access to the precincts of the Legislative Assembly. Furthermore, the Marshal cum security officer is entrusted to look after the security arrangements inside the precincts of the Assembly House along with the Assembly Chamber and is assisted by Deputy Marshal and internal security personnel of the Assembly House in maintaining peace and sanctity during the sessions of the Assembly. It is pertinent to note that none other than Sri Mihir Goswami had any reason to complain till date regarding arrangement of security made under the directions of the Honorable Speaker in respect of the Assembly. Then we'll at para 8. With reference to so and so, it is denied that only the security cover deployed for opposition MLAs are selectively restricted from entering the Assembly House precincts as alleged or at all. It is further denied that incidents have transpired surrounding the petitioners or otherwise within the Assembly House precincts which have made it imperative for the security personnel of CSF to be allowed entry within the Assembly House precincts as alleged or at all. It is further denied that, etc. Article 14 and all that. Now, the details of the security arrangements, your Lordship would find at page 10, subparagraph K. We're at page 10, subparagraph K. The Honorable Speaker is the head of the Secretariat, which functions under his ultimate control and direction. The Honorable Speaker's authority over the secretarial staff of the House, its precincts, and its security arrangement is supreme. All strangers, including security personnel, are subject to his orders. The Honorable Speaker, being responsible for the protection of the members, has made adequate and sufficient security arrangements and measures. Admission to the precincts of the Assembly compound, the Assembly House, including the chamber, the inner and outer corridors, as well as the galleries, are under strict control of the Speaker. There are 8 blocks inside the Assembly chamber. The sitting arrangements depend upon the number of members of the respective political parties, including Treasury and opposition members, and is accordingly decided by the Honorable Speaker. Detailed arrangements would appear from Annexure R3 hereto, and the systematic diagram of the Assembly House. Marshal cum Security Officer of the West Bengal Legislative Assembly is entrusted to look after the entire security arrangements inside the Assembly House along the Assembly chamber. He is assisted by the Deputy Marshal and internal security personnel of the Assembly House in the form of an exclusive watch and ward security cadre. Apart from this, 70 police personnel from Kolkata Police are exclusively deputed during the session under the Marshal cum Security Officer, West Bengal Legislative Assembly, to look after the security during sessions. Assembly security personnel as well as deputed police personnel from Kolkata Police, both armed and unarmed, are posted inside the inner veranda of the Assembly House. A comprehensive duty roster of the security arrangements during the 4th session of the 17th Legislative Assembly is annexed. A temporary shed made outside the Assembly House premises between gate numbers 2 and 3 has been earmarked for all security personnel, including the personal security officers of the ministers and members. No security personnel are allowed to enter with arms inside the main building. This is very important. Where Assembly chamber is located, consequent to the decision taken by the General Purposes Committee of the Rajya Sabha and meeting of the Honorable Speaker of the Lok Sabha and the leaders of parties and groups in Lok Sabha, armed escorts, PSO, Personal Security Officer, of Honorable Ministers, Honorable Members of the Parliament are also not permitted inside the Assembly House estate. Parliament House estate. They peel off from the vehicle at the respective iron gates itself. At no point of time, external security personnel are permitted inside the Assembly House. Entry through the gates of the West Bengal Legislative Assembly was stopped after an unfortunate incident which resulted in a copy made on May 6, 2021 by a representative groups of media, a copy annexed. In the last 3 years since the aforesaid incident, no occasion has arisen for any member to have any complaint with regard to security arrangements in the Assembly. Having regard to the tight-knit security arrangements, all members are safe, etc. Now, how is things controlled? In the Parliament, if your Lordship may kindly come to page number 27 of my opposition, where it starts from page 26.
Yes.
This is Lok Sabha Bulletin of 2024, 23rd June 2024. The relevant, if your Lordship may kindly have a look to page number 27, bottom. Carrying or display of firearms in Parliament estate. The carrying or display of arms and ammunition in any part of the Parliament estate is strictly prohibited. Only security personnel specifically deployed in the Parliament House, deployed in the Parliament House. This is very important. With authorization from Parliament security are permitted to carry arms. Kind cooperation. Then please take the number 46. I have placed 44. Keeping over 45, please take 46. Stoppage of entry of armed escorts, PSO, coming to the Parliament House estate. Consequent to the decision taken by the General Purposes Committee of the Rajya Sabha and meeting of the Honorable Speaker with the leaders of the parties and groups in Lok Sabha, armed escorts, PSO, personal security officer of the honorable ministers, honorable members of the parliament would not be permitted inside the Parliament House estate. They may peel off from the vehicle at the respective gates, iron gates itself, kind cooperation. Therefore, my lord, this is also the same arrangement, my lord, is in the Parliament building or my lord areas. Now, what is our arrangement? Please have a look to page number 38. This is West Bengal Legislative Assembly.
Yes.
But this is this was published on 19th of July 2024. I skip over the page 38. Please take page number 39 at the top. The southwest gate, gate number 2, has been earmarked for entry and exit of the leader of the opposition, chief opposition whip, MLAs and media persons. The vehicles of members will be parked at such and such place. Then kindly take the next page, page number 40, para 13 over there. A temporary shed made outside the assembly house premises in between gate numbers 2 and 3 has been earmarked for all security personnel, including personal security officers of ministers and members. No security personnel will be allowed to enter with arms inside the main building. This is what, my lord, the system which is also followed, my lord, in the Parliament. Now, my lord, to my opposition's page 6, 7, and 8, my lord, the reply, I mean, in the reply, it has been dealt with in paragraph 6.
Reply টা দেখে তুমি বাবু reply.
But on the legal issue, we have said a lot of things in our affidavit. I am not placing it for the time. Paragraph number 6, with respect to the contents of paragraph numbers 4 to 9, I deny dispute, etc. I say that the response number 1 falls within the definition of so and so under Article 226. The aspect of justiciability of the decision taken by the response number 1, I have already covered in the preceding paragraph, which are not repeated. I also say that the petitioners have already brought to the records of the details of the untoward incident which has transpired into the Assembly House, and it is unfortunate that the very occurrence of the incidents have been denied in the affidavit. I vehemently deny that the security personnel of all MLAs have been provided with a waiting space by way of a temporary shed at a well-demarcated site in between gate number 2 and 3 of the Assembly building. I say that the restrictions have only be imposed with respect to CISF and CRPF personnel deployed for security of the opposition MLAs, whereas the state government protectees have been allowed to enter into the Assembly House compound without imposition of any restriction. I also deny that there is no dearth of proper shed at the site where the security personnel wait. I rather say only the security personnel belonging to the central forces deployed for security of the opposition Bharatiya Janata Party MLAs are made to wait in the temporary shed constructed outside the gate in inhuman condition, being exposed to rain, heat and cold. There are even instances that during torrential rain, the security personnel deployed by the state government have been allowed to take shelter in the lobby of the Assembly House, whereas the security personnel belonging to the central forces have been compelled to wait in the outside shed in inhuman conditions. I specifically put it on record that all the opposition MLAs are aggrieved by the said discriminated restriction and time to time has expressed their anguish over the petition number 1 being the leader of the opposition. Moreover, it is on public domain that at present the leader of the opposition has severe threat perception from Bangladeshi terror organization as has been disclosed in the intelligence reports which went viral in media and clearly accepted. Now, the petitioner wants the writ court to go into this aspect, who is in the rain, who is in the heat, dust, etc. But these are the factual background. Therefore, I have troubled your lordship with these 2-3 paragraphs, which otherwise was not required. Now we are on the legal aspect, my lord. But only one more factual aspect, my lord. He has said in paragraph 12 of the writ petition, I've missed that. Paragraph 12 of the writ petition that kindly note paragraph 12, nothing much in that. Only state protectees are allowed to enter.
Yes.
But may I come back on next week sometimes?
But then what can be the reason for this distinction between the state and the...
There is no distinction. It's only a averment in the writ petition.
Are
There is no
the
distinction.
are the CISF, CRPF personnel allowed to enter? Why
No
only
one
they?
is allowed to enter. There is a space
State-
earmarked
Yes.
where everybody stays.
And the state
State,
protectees,
central, whoever is there, they are stopped at a particular place. And
everybody.
Yes.
It's not that only
No,
the
no, no.
CRPF personnel are stopped
no.
and the state people are allowed to
Central,
enter. Everybody.
Everybody. Only exception is that assembly house, they also deploy some police, like Muller.
Yes, yes.
Police in
Yes.
front of all the courtrooms.
Right.
This is deployed by the High Court.
Yes.
Whereas there are some people who have personal security. They are not allowed entry over here with arms. Even if your lordship has the experience of going to some, say, central government quarters or something like that, which is guarded by the CISF, your lordship's PSO will not be allowed inside because he carries arm. This is the culture everywhere.
So the case that is being made out of discrimination,
Rather, he is trying to get an order which would result in a reverse discrimination.
all right.
But nowhere it is allowed. I cannot say about the other states, but so far as the parliament and our state is concerned, Millard, our assembly is concerned, it is not permitted.
All right. When do you want to come back?
Day-to-day করে শেষ করে দিন না।
যেমন important মামলা তো
It has been demonstrated while we were arguing, my lord, about what is there on record. That my lord, the security personnel,
Wait. Let him finish thereafter.
my lord, kindly, my lord, hear it and decide it, my lord, on a day-to-day basis, my lord.
This is not so very important that day-to-day hearing is
So,
to
my
be
lord,
done.
question, my lord,
There are so many writ petitions pending.
my lord,
And see these type of matters.
saw Millard the crowd.
Just imagine. And with all these matters, if the board gets blocked, then it becomes very difficult for the regular
my lord,
matters
the
to be
question,
taken
my
up.
lord, the short question which needs to be answered on behalf of the my lord, honorable speaker is, my lord, as to whether constitutional provisions can be suspended by way of issuing an administrative letter, my lord. That is
Please
the
come.
short point. পরশু করে দিন না।
The learned Advocate General
বা 21 তারিখ
commences
করুন না, 3.5
argument,
আগে করে শেষ করুন।
but does not conclude the same.
What was it?
Stuff. Fix for further argument on. Would you come up with a date?
I understand the learned
Your understanding will not
will agree on the 21st of July, my lord. We can.
No. Do we keep it on 21st? List on 21st July.
Matter can be heard for the entire day and decided.
No, the court has other things to do. Matter heard for the entire day. It's not done that way.
No, 21 আগে করে 21 আগে পারবেন না। কোর্ট বন্ধ হয়ে যাবে, রেজলিউশন হবে।
resolution.
তুই আসবি আমি আসবো
There might be a resolution. But kindly takes it up sometimes next week, Marat.
No, no, 21st.
20. No,
It is your proposal.
Oh, it is only 8th, Marat. I thought we are on the 17th.
So what you thought
No,
is
Marat,
not you.
Marat, I got
21st and
Marat, I got confused. Marat, I got confused with the calendar, Marat. I thought that we are on the 17th. Marat, kindly takes it up. Okay, so that.
21st.
Marat, any day next week, Marat.
No, no.
Marat, any day next week.
Impossible.
Very well. Marat, kindly mark it as hard in part, Marat. Marat, hard in Marat for substantial period, Marat.
Have you seen any matter in my list mentioned heard in part?
Marat, I
Name
understand.
one single matter.
Marat, I understand, Marat, 21st, even if there is a resolution, Marat,
Yes.
matter will be taken
He
up.
can join online also, no difficulty, and the AG always joins.
I will
also.
be here, Marat, physically.
No issues.
Cool.
এখনই ফাইলটা পাঠিয়ে দিন।
Lord, I am for the Central School Service Council. Lord, Mr. Jana is appearing on behalf of the petitioner. My Lord, I am for the state.
Yes.
And on last occasion, your lordships directed me to bring the judgment passed by the Honorable Division Bench. Para 7, my Lord. Page 3.
Sama Prasad Rai.
Shama Prasad Roy.
Yes, para 7. Your lordship
Okay.
should be.
We give the
Just
respondent
verify
6 months
the-
time to find out the teacher to fill up the resultant vacancy which is created after transfer of the appellant within the aforesaid time or soon after the exercise should be transferred in accordance with law. All right.
My Lord, but here, my Lord, one.
Under which provision was this judgment passed?
My Lord,
3rd January notification.
certain
And the 3rd January notification, alternative arrangement. Division may said that the alternative arrangement cannot be made forever. My Lord, that is why division may 6 months time to find out the alternative.
The district inspector of school was directed to find out a suitable alternative arrangement, my Lord, in terms of the 3rd January. My Lord, even after 4 years, he has failed. So they are ultimately, my Lord, division bench.
In this case, for the petitioner
exercise.
also, he is seeking transfer for quite some time. When the portal was functional, then the application was made. Now, single teacher, if it is refused, then why will this Shama Prasad Roy not come to the aid of the
My Lord,
petitioner?
kindly turns to page 16 of this application, my Lord, filed by the petitioner, my Lord. I'm not opposing the prayer, my Lord, but my Lord,
16 of the application.
application, my Lord.
Yes.
School Service Commission returned my application on the ground of single teacher. Well, I have made out a case that the notifications has not come, amended notifications. Prior to amendment of the notification, I made an application.
At that point of time, my Lord, 3rd January notification was not there. Subsequently, 3rd January notification come into effect. So, my Lord, in the case, my Lord, where the division bench has ordered directing the district inspector of school to find out an alternative arrangement within 6 months, and if he has failed to transfer the petitioner after 6 months, my Lord, here no such exercise has been carried out. My Lord, first to find out whether any alternative arrangement.
Obviously, we'll find out whether any alternative arrangement can be made or not. If it is not, then 6 months' time, the division bench's order will follow.
Great.
Please come.
My Lord, kindly do not record that I have faced this. Kindly record.
No, it is the division bench's judgment relying on which the order will be passed.
Relied by Mr. Jana.
Yes, I have submitted. I have relied. I have handed over to my learned friend, my Lord.
The application seeks recalling the order dated 25th April 2025. Passed by this bench. Stop. The ground for seeking recalling is that the transfer application was made by the petitioner prior to the notification of the School Education Department Secondary Branch dated 3rd January 2022 coming into force. Stop. The petitioner applied for transfer in the year 2021 and the application stood rejected on the ground that the petitioner was a single subject teacher. Stop paragraph. Till date, the application for transfer of the petitioner could not be considered because of the same reason. Stop paragraph. Learned advocate for the petitioner relies on the order passed by the Honorable Division Bench of this court on 9th June 2025 in MAT 488 of 2025, Can 2 of 2025, within bracket, Shama Prasad Roy versus State of West Bengal and others, wherein the court observed that the respondent authorities cannot, on the pretext of non-availability of a willing teacher, indefinitely keep the application for transfer pending. Stop. The court clearly held that an application for transfer cannot be kept in abeyance unreasonably for an indefinite period of time. Stop. Under such circumstances, the court fixed 6 months time, not fixed, gave 6 months time to the respondent authorities to find out a teacher to fill up the vacancy to be created on the transfer of the candidate. Stop. The candidate within the scheduled period of 6 months or soon after the expiry of 6 months period should be transferred in accordance with law. Paragraph. In the instant case, the petitioner is seeking for transfer since 2021 onwards. Stop. The respondent authorities are directed to find out an alternate arrangement to cater to the resultant vacancy to be created on the transfer of the petitioner. Stop. The respondent authorities shall act within a period of 6 months from the date of communication of this order. Stop. If the petitioner shall be transferred within the aforesaid period of 6 months or immediately on completion of the 6 months time period.
If he is otherwise eligible, madam.
Provided the petitioner is eligible for the same.
Great.
Transfer on distance ground, what eligible, my lord? The
writ petition stands disposed of.
this is application for modification.
Writ petition application stands disposed of.
Only one line.
But I'm unable to put my name in the chat box.
Yes, please.
My lord, I'm unable to give my name in the
Achha,
chat box because it is disabled.
Ajay Shantanu Mitro. Naki Kumar Shantanu for
Yes,
for
madam.
the state respondent. Yes, your name has been recorded.
Melody,
Mr.
kindly
Jana,
add one line, Melody, suspension of portal will not be a ground, Melody, for taking a decision.
By the honorable
Melody,
court, my lord.
otherwise, they will say, Melody, suspension, now the portal has been suspended. There is a division man judgment, my learned, I have a copy of the division man in my junior. The copy, downloaded copy should be submitted to the DI of schools.
Achha, the respondent authority shall act on the basis of the server copy of the order downloaded from the official website of the court, irrespective of the fact of suspension of the portal of the suspension of the Utshostri portal.
Great.
The petitioner, however, will be obliged to forward a physical copy of all documents in support of his transfer. ঠিক আছে।
Deeply obliged.
In item number 1, Your Lordship, the petitioner received her passport yesterday, Your Lordship.
Right. The grievance of the petitioner has been redressed and the petitioner has received her passport. Stop. In view of such submission, the writ petition stands disposed of.
Lordship, we have dispatched it on 4th of July, Your Lordship.
Petition number was wrongly recorded in the order dated 24th June 2025. Stop. Let the same be corrected. Writ petition disposed.
Much obliged, Your Lordship.
I'm obliged.
Wait, please, Your Lordship. But I'm being led by Mr. Anbotchaj. Well, it essentially pertains to challenge to an order or a preventive detention order passed under the Mallet Prevention of Immoral Mallet Illicit Traffic of Narcotic Drugs and Psychotropic Substances Act, which my lord would find at page 26 of my lord's brief.
Who is for the respondents?
My lord, we are appearing.
You are representing?
All the respondent.
All right. The Union of India Narcotics Control Bureau also?
Yes.
All right. Why are you inquiring whether
I was just
seeker? You pray for
I was just-
make your
I'll tell you.
submission.
Well, essentially in 2021, this particular petitioner, he was blemish free. However, in 2021, 8 different cases, narcotic cases were registered against him. In none of the cases, he was found to be in possession of even a single gram of any narcotic or contraband substance. What happens is most of these cases were registered, to be precise, 7 of them were registered outside his state by the Narcotics Control Bureau. My lord would find, in fact, the allegations are overlapping. I have given a chart of the same at page 3, paragraph 5 onwards. Out of 8, my lord, as on date, either I have been acquitted, discharged, or bailed out in 7 of the cases. In Kolkata, I presently have about 5 cases. In none of the cases, I am in custody. I am in custody in 2 of the cases because I could not furnish bail bonds.
Are you originally from Kolkata?
I am originally from, my lord, Bangalore. I was served with the preventive detention order at Presidency Correctional Home. While this honorable court was hearing my bail application from time to time, which was the last, my lord, to say the last case in Kolkata, surprisingly, a cryptic order is being passed, which my lord would find at page 27. By respondent number 2,
which neither specifies the tenure of detention against which the detention is passed. Well, there has to be a proximate link. It has to be immediately passed. Why this was passed?
Preventing him.
And my lord, more importantly, it does not even specify what was the urgency in not giving me the relied upon documents or reasons were never furnished to me.
Where is he now? In the
In Presidency Correctional Home, my lord, kindly flip over to the next page, 28.
Because this says about the Jaipur Central Jail,
My lord,
Rajasthan.
they seek to transfer me to Jaipur.
Right.
5 cases are pending here.
Yes.
Now, what they seek to do is, in none of the cases, from 21, they could even complete the trial. In the Bangalore case, I stood acquitted because nothing was found against me. Now, my lord, subsequently in 1906, my lord would find this honorable court grants me bail in the last case as well, which was pending. My lord, absolutely an act to circumvent the court's process. But how can this be? My lord, the honorable courts have held from time to time. This cannot be a punitive action. This is a preventive action. And in fact, in terms of their own circular, just place the circular before your lordship once. My lord would kindly see 3. দেখলেই বুঝে যাচ্ছে। Advisory board, nothing.
Tell me, what is the reason for keeping him in detention?
Section 3, subclause 1 of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substance Act.
Yes, take it.
When series of NDPS case pending against a persons to further commit further, for that reason central government or state government has a power to pass the preventive detention order for a period of 3 months. Then as per advisory board,
Then I can see from the order that is annexed at page 28, he was in custody for 2 years and 4 months.
Yes, ma'am.
Right. Is further custodial interrogation required? Is for preventive detention, I can see.
Preventive detention is as per section 3 subclause 1. Why necessary? This is 8 cases of NDPS case has been registered against this petitioner.
Yes, he'll face trial.
Yes.
What is the
That is pending, but
requirement of keeping him in custody or transferring him to Jaipur Central Jail?
No, my lord, to further not to commit any offense such like for that reason, my lord, preventive detention order is my lord NDPS Act. This 88 Act, my lord, section 3, that is my lord has power to state and the my lord, central government. My lord, yesterday we have received brief. We have filed a report, my lord, from the concerned department, my lord, from the
I would also see T3 once, whether that was complied. Within 5 days, they had to intimate me. This was of May. Within 5 days, was not intimated.
When did you get it?
My lord, sometime in the month of June. Even after 15 days. So, that is not
them file a report, please come. The petitioner is aggrieved by the order dated 16th May 2025. Issued by the Joint Secretary to the Government of India, Ministry of Finance, Department of Revenue, within bracket, PIT, NDPS unit. They can even page 27. Stop paragraph. It appears that the petitioner has been granted bail by a coordinate bench of this court on 19th June 2025 in CRM bracket open NDPS number 619 of 2025, wherein the court recorded that the petitioner was in custody for about 2 years, 4 months and no recovery was made from him. Stop. The trial could not be concluded for no fault of the petitioner. Stop. Paragraph, it has been submitted that there is no evidence against the petitioner, and by the impugned order, the authority is trying to circumvent the provision of law. Paragraph, learned advocate representing the respondent authorities seeks time to file a report. Stop. Let a report be prepared and circulated by
2 weeks.
25th of July.
Yes.
Exception, if any, may be filed within 10 days thereafter. Stop. Let the matter appear in the list on 25th August 2025. Stop. The respondents are restrained from taking any step and or further step in furtherance to the order dated 16th May 2025 till 26th September 2025 or until further order, whichever is earlier.
I'm deeply obliged, my lord.
Whether, my lord, this order has been executed or not, my lord?
No, no, it's not.
Order.
No, not executed.
He is there.
Wakalat number is the residence.
Yes.
Grateful matter.
But I beg to appear for the petitioner.
I appear on behalf of the respondent number 529.
Lord, kindly take, Lord,
1 minute. Who's for the bank? You are there for the bank?
Lord, kindly take page 53 once. Bank is here, Lord. Lord, page 53.
Yes.
Lord, this is under challenge before your Lordship, Lord. I will tell you, Lordship, the background, Lord, a little later on. Several litigations have taken place in between the parties. Several protective orders have been passed by your Lordship's coordinate benches.
Parties means?
Between the bank and me. Bank and me. Lord, on 24th of June, kindly come to 53.
Yes.
appear করিনি
53.
53. Lord, 24th of June, they submit this notice. They affix it. They don't address it to me. Kindly see what they are saying. As per the order of the DM, executive magistrate is authorized to take a possession of the secured asset. So and so, so and so. Now the executive magistrate and the police jointly have fixed the date for 9th of July. Take physical possession of the above mentioned secured asset. Lord, kindly take the next page, the order. Lord, the order was obtained ex parte. Lord, I received this notice on 2nd of June. 3rd of July. 3rd of July, sorry. 3rd of July, 3rd of July, I received this notice. Kindly take the next page, 18th of March. The order has been passed. I don't know by whom, but if my lord sees page 56, somebody writes on behalf of the TM. But that's also contrary to the statute. Nobody can pass order on behalf of the DM. Who has passed the order? That I don't know. Page 56. Now, this order has been passed ex parte. On 3rd of July, they sub me a copy saying that affix the copy saying that on 9th of July, they will take possession. Lord, section 17 gives me a right to challenge any order passed under 13.4. 14 is in end of 13.4 within 45 days. Lord, I am only on that point coming before your lordships that the basic minimum time which is required to be given to enable me to challenge it before the appropriate forum is not given. It's an ex parte order. They obtained the order. They kept it with them from 18 March. On 3rd July, they fixed it in my house. And 9th July, they are going to come back and take possession. Now, kindly take the list of date. Your lords will get the background, what is being happening in this matter. Kindly have a look at this.
Who are you, the borrower, the guarantor?
Lord, I am the legal heir of the owner of the land. Kindly have a look at the list of it. Just have a look at this. Why this is important? Just have a look at it.
No. What is your status? You are.
Lord, I am the legal heir of the owner of the land. The borrower is a company. My mother, she was a guarantor.
My mother was a guarantor. The loan is in the name of the company. In earlier 4 writ petitions, 3 writ petitions, now kindly take the list of date. 5th of August, mother of the petitioner died. 3rd March 2022, 13-2 issued in the name of the dead person. 8th June, symbolic possession, 13-4 issued. 23rd February, sale notice issued. 31st March, sale notice stayed by DRT. We took our section 17. 2nd May, status quo order passed in title suit that we taken. 25th May 2023, Lord Justice Chaudhary.
Title suit against whom?
Lord, it's a partition suit. It's a partition suit. 25th May, Justice Chaudhary stayed the Lord SARFAESI action itself in its entirety, saying that a notice has been issued in the name of the dead person. Lord, 8th September, writ petition got dismissed by Malaya Partha Sarathi Chatterjee because the bank came, said that we are withdrawing the notices. So nothing survived. Then 29th of January 2024, Justice Sabyasachi Bhattacharjee again directed status quo and allowed the petitioner to approach DRT again. Then 5th of April, Lord, the time to approach DRT was extended by my Lord. 29th of April, DRT heard the application, rejected because I filed it on 9th of April instead of 8th of April. Again, we came to Justice Bhattacharjee. Justice Bhattacharjee allowed, Lord, extended the time. DRT ultimately dismissed it for default because the lawyer, or my junior, he could not attend that at that point of time. Now, 2nd July 2025, we are notice dated 24th affixed along with 2nd July, 3rd July, which is under section 14 directing delivery on 9th July. But I have a very simple issue. On the last 4 occasions, they knew that I am fighting. I'm so sorry. I'm so sorry. No, again.
Continue, I can hear.
But kindly come to 53 once. Kindly see whether it is in my name or not.
No,
This is the 4th time. 4th time I'm coming. They knew every time I'm there. Courts are protecting my right. Orders are being passed in my matters. What is their problem in addressing me a notice? And this is the order which has been considered by Malaya Justice Bhattacharjee, Malaya Justice Chaudhary in the earlier round of litigations. Kindly come to Malaya Justice Bhattacharjee's order once, page 35. Now, my Lord, I am on a very simple point, my Lord. Section 17 says I have 45 days to prefer an appeal. You got the order on 18th of March. You could have submitted on 19th of March. You kept it in your closet, pasted it on 3rd of July or 2nd of July, giving me 7 days time. It's impossible humanly for me to get the matter filed in DRT because it's online filing. A lot of scrutinies are being done. I'll be non-suited. What were they doing? I'm not inviting you on the merit of the order, but kindly have a look at it. Who is passing the order? Page 56. Somebody for the DM, whether he's a peon, he's a group D staff, group C staff. I don't know. Neither it appears from the order. But I can understand DM authorizes ADM. They are of the same rank that your lordships have held. Kindly see whether it appears or not, that whether the ADM has passed the order. It could have been by anybody. For DM. My Lord, is at page 54, kindly see. Whereas the authorized of the Indian bank has filed so and so, name of the address of the bank and borrower, and whereas it transfers from the record that so and so is the due, and whereas CSARI registration, then in the next page, if my Lord turns the page, now therefore considering the entire gamut of the situation and light of the statutory provision and relevant documents here is submitted, the authorized officer so and so secured creditor affidavit requested for possession of secured asset. Further, the Commissioner of Police Howrah take necessary action. Mr. Swanso, WPCS, will take possession. So from 18th of March, this order, even if I take it that this was passed by the DM, is with the bank. Kindly see, my Lord, it was addressed to the, it was given a copy to the bank.
The 45 days time limit does not run from the order passed under
But
section
if I do
14.
not know the order, how will I challenge it? May I ask this question to myself?
It runs from 13.4, right?
Lord, yes. Now I must have the copy of the order. It is their duty to let me know. Lord, I am on this very basic thing, Lord, that they have kept the order with them. Lord, if your Lordship allow this today, then I being a bank will get an order today, keep it with me. On the 44th day, I'll give it to the party and take possession. They could have given me a copy. I could have challenged it. If they have not given me, Lord, how can I challenge it? May I ask this question to myself, Lord? I did not know of this order. It's not their case that they served me on 19th of March.
So it is not your case. It's 45 days from the date of knowledge. Here it says
from the date I receive it.
from the date of the 34.
Kindly take section 17 once.
Yes, please.
Lord, kindly see the last line, on which the measures had been taken. So the measure.
Yes, I'm aware. Yes, the bank.
Lordship, my first submission before your Lordship would be, Lordship, it's a classic case how the scrupulous litigants are taking undue advantage of due process of law. The facts as pleaded by my learned senior friend before your Lordship has not been in its true facts. Initially, who is the petitioner? The petitioner is none other than the one of the legal heirs of the mortgager. Admittedly, the mother has mortgaged the property, more than 50 crore due and outstanding. Bank was initiating proceeding in accordance with law. Bank has issued 13.2, 13.4. All legal heirs are already on record.
Why is the petitioner not on record?
Lordship, the case of the bank was completely in dark. The case of the petitioner is there. She got married as way back in the year 2003. And she was residing in Kerala. Now, what is the case of the petitioner? The case of the petitioner is not that the SARFAESI action taken by the bank is not in accordance with law, or the bank is not in dues, or the property is not secured assets. The case of the petitioner is that she is one of the legal heirs. She has not been served with the 13.2 notice. Per contra, all the legal heirs has been duly served as way back.
The deceased mortgager had any other legal heirs?
Lordship?
Did the deceased mortgager have any other legal heirs?
Yes, all are in writ petition. Brother, sister, all are in writ petitions except her. Because the bank was completely in dark.
All right.
What happened, your Lordship? The bank was taking SARFAESI action. All on a sudden, the petitioner came and I have not been served. Filed a writ petition before the coordinate bench of this honorable court.
So the private respondents are the siblings of the petitioner?
Yes. Yes. Thereafter, what happened, your Lordship? The coordinate bench, when initially they have approached the honorable court, was of the view, since your grievance lying before the Debt Recovery Tribunal, you go and file there. I am giving you a liberty to approach the tribunal with the breather, 14 days breather. They failed to. Once again,
that he is placed.
Yes, once again come to the writ court.
That has been
Yes,
placed.
Ken application. Kindly see the conduct. Ken application has been.
So, your cases, you were not aware of the existence of the petitioner.
Yes.
Is this the first time that the petitioner is coming up?
Lordship.
Earlier
Page 47, he appeared. Page 47. He
Please.
appeared.
The earlier writ petitions,
Yes.
those have been referred to.
Yes.
Was it filed by somebody else or by the petitioner?
By the petitioner.
Then you knew.
And in view of the order of the honorable court, they have filed a DRT proceeding before the tribunal. What is
That
saying?
got dismissed.
That got dismissed in the month of January.
Right.
She is sitting idle. She is saying, I am not aware. But whenever bank is taking possession, she become aware. But she is saying, I am not aware. Got dismissed in the month of January. Kindly see the orders.
Yes.
The tribunal granted 2 opportunities in view of the order passed by the honorable court to ventilate their grievance. They did not turn up. The only intention to still the process. When the tribunal taking conduct of the petitioner, your Lordship, I have entire order I have annexed.
All the orders.
All the orders passed by the tribunal. Last 2 orders kindly take up, your Lordship. Last 3 orders. The last 3 orders, the last 3 page, 24th of July. Order passed by the tribunal. The petitioner did not turn up. Your Lordship, kindly see the last paragraph. As the applicant is not present, applicant side is informed. Applicant is strictly directed to pursue the matter. Categorical direction. Kindly turn the next order. Once again, they did not turn up before the tribunal. Once again. Your Lordship, nobody appears on behalf of the applicant. London Council on behalf of the defendant bank appears virtually. Was earlier dismissed for non-prosecution such and such, and essay was filed against the same notice. Copy of the order passed by the Honorable Court, Calcutta in writ petition number such and such, dated such as have been placed. List the matter on such and such along with all the dispose of the matter, along with the dispose of the matter as a number such and such. Order uploaded in the tribunal. Subsequently, matter not taken up due to paucity of time. Once again, 28th of January, the matter was taken up for hearing. Lordship, kindly perused. None appears on behalf of the parties. London Council for the defendant is present. Nobody appears on behalf of the applicant. London Council for the defendant appears virtually. On the last date, that is on such and such date, and the earlier occasion also nobody represents the applicant. It appears that the applicant is not interested to prosecution of the case. Hence, the case is dismissed for non-prosecution. So the liberal approach of the tribunal given to the petitioner has been availed of but not pursued. Got dismissed. Sitting idle. February, March, April, May, June, July. Let's say the bank has auctioned the property. Your Lordship knows, subsequent to auction, the bank is under obligation to hand over the physical possession. Property is mortgaged with the bank. Now the bank is trying to take physical possession of the property. All legal years kindly take judicial note of the same. The rest of the legal years till today has not challenged the SARFAESI action. They're simply putting the petitioner, you are not the party, you proceed. But she was sitting idle for a period of 6 months. All of a sudden, she come to the writ court. Why she was trying to get a restored this section 17 application only to stall the process. Tomorrow is the date of taking physical possession. Kindly allow them, breather, once again stall the process. More than 50 crore. Your Lordship, SARFAESI Act, the recent judgment passed by the Honorable Apex Court in Salary Bafna, once the property in auction in public platform, that cannot be set aside. There is a provision for redemption. He is saying she is one of the legal heirs, she has a right. So you have to accept the liabilities as well also. What is their offer towards the dues? She entitled share in the property, but I will not take the liability of the predecessor. Where is the color of money? Kindly see the conduct. And court cannot give, with due respect to my submission, Your Lordship, subject to Your Lordship kind consideration, such a litigant cannot be allowed to miscarriage of justice by taking undue advantage of due process of law. Section 13, right of redemption is there. They have not made any redemption application even before the bank. No repayment schedule. All legal heirs are aware. They are not challenging. Lordship, if Your Lordship kindly peruse the judgment passed by the Honorable Apex Bafna Motors.
Yes, please.
Sanctity of public auction should not be disturbed. Property vikri hoye gaye. Sales certificate has been issued.
There was a status quo from the tribunal.
Where is this provision for redemption? I found
Lordship, section 13A of the SARFAESI Act.
13.8.
8.
All right, all right.
Where the amount of debt dues of the secured creditor together with all costs, charges and expenses incurred by him is tendered to the secured creditor any time before the date of public notice for public auction or inviting quotation or tender from public or private TT for transfer by a lease, assignment or sale of the secured assets. The secured assets shall not be transferred by way of lease, assignment or sale by the secured creditor.
No, this step is over. Because here sale.
None of the legal heirs stand up to tender the redemption. Even petitioner is all not seeking for redemption. She has a right over the property. I am not concerned with liability. I have accrued a right without liability. I am putting this question to myself. How is it possible? Where is your bona fide? Discharge the obligation. Sitting in Kerala, getting every information and saying, I am not aware. Liberal approach of the Honorable Court also availed. Declined to pursue. Tribunal take cognizance, dismiss the same.
Yes, private respondent, what is your stand?
Sir, my instruction is that we have not received any amount of notice. And despite that, there is a partition suit. And in the partition suit.
What has the partition suit got to do with this?
There is a status quo.
All right, you go before the civil court. What is?
We don't have, my lord.
What you don't have?
The DM has already acted upon a
So the challenge is that the DM has not passed the order.
It's a ministerial act, my lord.
The DM has passed the order.
Lordship.
All right.
Ministerial.
Lordship, no, section 14, borrower has nothing to participate in the ministerial act in terms of the order passed by the Honorable Apex.
Ministerial act, my lord. Service or notice is not necessary.
And Lordship, Bafna order in page 83, page 137. Sanctity of public auction.
Para 83.
Para 83. Petition is aware the properties has been auctioned. But despite they are not tendering a single.
Which page do I get that?
That's a page 137.
137.
প্রত্যান কবে হয়েছে?
January 2024.
আচ্ছা।
Show me document to show that it has been put up in auction
Yes.
and sale certificate has been.
The sale certificate has been issued. I have a document, Your Lordship.
Please show.
Page 41.
Lordship, I'm missing in my brief, but I'm having during
Lord,
10 to 15 minutes I can find.
Page 47, Justice Sobhusachi Bhattacharya's order, 15th May 2024, status quo order was passed. Initially on 29 January, then 15th May 2024, status quo order was passed. Tribunal was directed to proceed with the application. The application is dismissed on January 2025. And he is saying in January 24, auction has been done. There was an order of status quo by your Lordship's coordinate bench. He did not answer what has been it doing from March to July, why this order was not served on us. And ministerial act doesn't mean that anybody can pass the order. The peon, chaprasi, anybody can pass the order. But Mr. Galib is submitted.
Also, this is another judgment subsequent to Bafna, where the honorable apex clause is held once the property is auctioned, cannot be set aside, save and except the ground of fraud.
Fraud. Last.
But they have no case and stay in the entire recovery process of the bank.
I have received an WhatsApp message, Milord, that he says Poshim, yes. DM Poshim Bardhaman has passed an order by district.
দিচ্ছি দাদা আমার তো নিজেই তো
যেটা দিলি যাচ্ছে
দিচ্ছি ওটাও দিচ্ছি আপনাকে আপনাকে দেবো কেন না দেবো কোথায় আছে কোথায় আছে ও? ধরুন দাদা ট্রাইব্যুনাল বলেন Also, kindly read paragraph 82 regarding redemption. What the observation of the Honorable Apex Court. 82, page para 82. Thus, it is necessary to interpret the amended section 13(8) of the SARFAESI Act in such a manner where a legal sanctity is attached to the auction process and a bright line is drawn where a mischievous borrower is told no more, no further, and precluded from hostility exercising in right of redemption from now nowhere at the very end of the process. Para 82. And the subsequent judgment, auction cannot be set aside save and except on the ground of fraud. No case of fraud has been made out.
13(2) issued against the dead man not served.
लेके दो उनको कहाँ है कैसे रखती
Must have been after January 25.
Auction come हुआ
January 24. Very well. That will help us.
দিচ্ছি দাদা সকালে দিয়েছি বৃষ্টিতে সে এত বৃষ্টি কিভাবে এসছি জলে ঢুকে
Lord Malloy, kindly take the writ petition once in my reply. Kindly come to page 35. My learned friend says in January 24, the property has been auctioned. That's his case. But kindly come to page 35, order dated 29 January 2024. Lord, at the first page, you'll also see for bank, 3 lawyers appear. Malloy, kindly got that? Then kindly come to the next page, page 36.
Yes.
Page 36, kindly sees thereafter issuing para 5. The banks.
Yes. What's the sale certificate?
Yes.
Please, can you tell us the date?
আমি দিয়ে দিচ্ছি সেল সার্টিফিকেট দিয়ে দিচ্ছি
Yes. Very well. ডেটটা একটু বললো শুনো। ডেট কত? দেখো তো ডেটটা দেখো তো। Thereafter, without issuing any notice, 9/5/2024. 13/4, the bank took steps for holding an auction sale regarding the property of late Modhu Kedia, which has now devolved on years. This was my case, being agreed present representation of. However, during the pendency of representation, that a date of auction sale elapsed, apparently without any participation of sale. So on that date, there was no sale done, 29th of January. Kindly, my lord, I will not insist your lordships to read the entire order. Kindly come to the ordering portion. What the court says, page 39. Para 18. Respondent bank shall maintain status quo with regard to the disputed property till February 15, 2024 until further order, if so passed. Then we approached the DRT. Then we again came back. Kindly take the last order of Justice Bhattacharya at page 47. All along bank was present. Lord, the sale certificate handed over to your lordships is 9th May 2024. Kindly mark this date and kindly see Justice Bhattacharya's date. And kindly appreciate who is playing fraud. On 15th of May 2024. Maharaj, kindly got that? I'll read this entire order with your lordship's liberty. Bank is represented. Whether
Not the entire order.
whether they inform the court that sale is being done till such time all along status quo order was there. Then kindly come
Not
to.
all along.
Yes, there was no. The status quo order continued.
It was till February 15, 24
February
or until
15?
further order passed by the tribunal.
Passed by the tribunal.
Thereafter, the tribunal passed order.
No, that is set aside then. That was set aside in this writ petition.
Set aside by
Page
order
41.
dated
Page 41. 5th April 2024. 29/4/2024. 29 January. Not kindly come to page 42, para 6.
Yes.
Accordingly, the order dated January 29, 2024 passed in WPA is modified to the extent the time for the petitioner to make an application before the Kolkata tribunal is extended till 8th April. Status quo with regard to the disputed property which has been passed in the said order is modified as is also
Extended till April 12, 24.
April 12, 24. Maharaj kindly got that. Then kindly come to page 45. 29/4/2024.
Yes.
The tribunal dismisses my matter. Kindly sees why. Last paragraph, it's not very legible. Kindly take the next page. In view of the matter, the applicant cannot stand disposed of. Why? I filed on
Which page?
page 45, 46. I'm so sorry, my lord. This is
45,
not at all
46, yes.
readable. My lord, I filed it on 9th of April instead of 8th of April.
Right.
Tribunal dismissed.
On
Tribunal
9th
dismissed.
9th May, there was no interim order.
Tribunal dismissed it.
Yes.
Tribunal dismissed. I came on 15th of May. Court, my lord, on 29th April, it is dismissed. To put a property on auction, there has to be a notice of 1 clear month.
Listen.
15th May, the court
there is a
reimposed
sale
the
certificate.
court reimposed the order of status quo. 15th May. The bank
There
did not
was an
inform.
interregnum
The
period.
bank did not inform that there is a sale. Lord, kindly appreciates, my lord. Order has been set aside. It will relate back to the date.
No.
Yes, not
Certainly
subject to
not.
correction. I tell you also why. Lord, kindly allow me to
Anyway.
explain. Kindly allow me to explain why. Lord, the High Court passed an order of status quo, sent it back to the tribunal. Tribunal dismissed on 29 April on a technical ground. High Court set aside the order and reimposed the order of status quo.
Let's kindly see the regarding auction.
You will have your turn.
The Honorable Coordinate Bench has taken cognizance, page 40.
Justice Bhattacharya on 15th of May reimposed the order of status quo, and the bank did not inform Justice Bhattacharya.
Status quo.
Yes, kindly sees the order. Kindly sees the order.
As page 40, the cognizance was taken. If any property is being auctioned, sale certificate should not be issued. Interim order vacate, bank had issued sale certificate.
Sale certificate.
Page 40.
Page 40 that has been set aside. What will the consequence? Page
40 of the
51.
Honorable
Please don't argue
order,
with me.
sir. I am not arguing with you, sir. I am making submission.
Kindly come to page 47. This is what a judge's order. The order of DRT was set aside 29th April. The matter revived. Even if there was any sale on 9th of May, that's 9th of May, the certificate has been issued. When was the publication done? Let me see it. Kindly allow me to place their submission before Justice Bhattacharya, page 48. Kindly have a look at it. Kindly have a look. Kindly have page 48, last paragraph. The learned counsel appearing for the bank strongly opposes the writ petition and submits that petitioner does not have a right in law which has been infringed in the present case. Secondly, the petitioner, it is argued, was not vigilant despite having been granted opportunity twice. Petitioner failed to file the challenge before the tribunal in time, leading to the dismissal in the challenge. Thirdly, it is argued that equities ought to be treated on an equal footing. If equities both sides are equal, the law should prevail. In the present case, bank argues that sale of the disputed property has already been confirmed, although due to certain technical reason, the sale certificate has not yet been issued. On 15th May, not issued. Then how come this come on 9th May?
Because the interim order vacated. Because
But it's dated on 9th May.
Please come.
This is dated 9th May. 15th May sale is not issued. But I'm grateful to this.
The matter relates to a property which was mortgaged to the Indian bank. Stop. The bank took steps under the provisions of the SARFAESI Act to recover the loan amount. Stop.
Lord, may I take a lordship?
In March 2025, now, as on March 2025, the due amount was rupees 26,45,00,000 within bracket rupees 26 crore 45 lakhs. Stop. The account became NPA with effect from 28th January 2023. Stop. Statutory notice under section 13 within bracket 2 of the Act was served upon the borrower on 15th July and 17th July 2023. Stop. Steps under section 13 within bracket 4 of the Act was taken in July 23 and a newspaper publication was made in October 23. Stop. The paragraph, the petitioner is currently aggrieved by the notice affixed to the wall of the subject premises dated 24th June 2025, directing the notices to hand over possession of the property. Stop. The notice, the impugned notice mentioned that 9th July 2025 is the date fixed to take physical possession of the secured assets with the help of the magistrate and the police. Stop. Paragraph. The petitioner submits that no notice was served to the petitioner intimating the steps taken under section 14 of the Act. The notice for handing over possession, though dated 24th June 2025, was affixed to the secured asset only on 2nd July 2025, when the petitioner got the knowledge of the same. Stop. It has been submitted that despite the bank knowing that the petitioner is one of the legal heirs of the deceased mortgager, did not issue any notice to the petitioner, violation of principle of natural justice has been pleaded. Stop. Prayer has been made to set aside the impugned notice for taking over possession of the secured asset. Stop. Next. During the course of argument, learned advocate for the petitioner has taken the court through the various documents annexed to the writ petition. Stop. It appears that the petitioner approached this court on an earlier occasion. Approached the court on a number of times earlier. Stop. Initially, a writ petition being WPA 1599 of 2024 was filed by the petitioner challenging the 13-2 notice issued by the bank. Stop.
But only one interruption. But initially the writ petition was 12679 of 2023.
Page 35 is not the first order?
No, my lord. Prior to that, my lord, there was an order passed in. But that order, my lord, does not form a part of the writ petition, my lord. I have handed over the list of dates, my lord. Your lordship will get the date, my lord.
Lordship, may I take leave of your lordship?
My lord, it is also in paragraph 3 of my writ petition. I have pleaded the prayers.
কি বললাম? WPA number 12679 of 2023 was filed challenging the 13.2, 13.4 notice issued by the bank. 13.2 and 13.4. ঠিক আছে? It has been submitted that video order dated 25th May 2023. The court was pleased to stay the proceeding under the SARFAESI Act. Stop. The writ petition, however, got dismissed on 8th September 2023. 2023. 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 2023 20 holding that the same became infructuous. Second writ petition was filed, paragraph D, was filed by the petitioner being WPA 1599 of 24. Challenging further steps taken by the bank to issue notice under section 13(2). And 13(4). The court video order dated 29th January 2024 was directed to dispose of the writ petition
Position notice.
directing the bank to maintain status quo with regard to the disputed property till February 15, 2024 or until further order passed by the tribunal. Stop. The petitioner was granted liberty to approach the tribunal with this same relief as sought for in the writ petition. Stop. The court recorded that if any portion of the property has already been sold, the same would be subject to the orders passed by the tribunal if approached by the petitioner. Stop. The court also restrained the bank to issue sale certificate in favor of any third party till February 15, 2024, had the property been sold off in the meantime. Paragraph. যেখানে বললাম না লিভ টু অ্যাপ্রোচ দি ট্রাইব্যুনাল ওখানেই লিখে দিন within a fortnight from date. ঠিক আছে? As the petitioner failed to apply before the tribunal within the stipulated time period, the tribunal was pleased to dismiss the application made by the petitioner. Stop. Challenging the said order, the petitioner filed an application before this court. Stop. The court video order dated 5th April 2024 was pleased to modify the earlier direction passed on January 29, 2024 and extended the time limit for the petitioner to apply before the tribunal till April 8, 2024. Status quo was directed to be maintained till April 12, 2024. Stop. as the petitioner failed to approach the tribunal within 8th April 2024. The tribunal dismissed the application filed by the petitioner on 29th April 2024. Stop. Challenging the same, the petitioner filed a further writ petition being WPO 406 of 2024, which stood disposed of by the court on 15th May 2024. By setting aside the order passed by the tribunal and restoring the application filed before the tribunal, applications to their original files and number, and directed the tribunal to immediately proceed to decide the applications on merit. Proceed to decide the applications on merit. Stop. Paragraph from the order sheets of the tribunal annexed to the writ petition, it appears that on 28th January 2025, none appeared on behalf of the petitioner before the tribunal. And the matter stood dismissed for non-prosecution. Stop. আচ্ছা এই নন প্রসিকিউশনের আগে 28th জানুয়ারির আগে একটা প্যারাগ্রাফ লিখুন তো। The matter was the applications filed by the petitioner before the tribunal was taken up for consideration on 24th July 2024 when none appeared on behalf of the petitioner. Stop. Noticing the order passed by the High Court in WPA 1599 of 2024 and WPO 406 of 2024, the tribunal directed that the applicant shall be informed and the applicant should prosecute the matter. Stop. The matter was directed to appear in the list on 26th September 2024. Stop. It appears that on 26th September 2024, none appeared on behalf of the applicant once again. Stop. The tribunal was pleased to adjourn hearing till 29th November 2024. Stop. এরপর যেটা আগে বলেছিলাম 28th January, the matter was thereafter taken up for consideration by the tribunal on 28th January 2024, and as none appeared on behalf of the petitioner, the tribunal was pleased to dismiss the applications. By observing that the applicant is not interested in the prosecution of the case, and hence the case to dismissed for non-prosecution. সিকোয়েন্সটা মেনটেন করবেন ঠিক আছে paragraph it has been submitted on behalf of the petitioner that the bank is intentionally and deliberately not issuing any notice upon the petitioner despite the bank being aware that the petitioner is one of the legal heirs of the deceased mortgager. ঠিক আছে It has been submitted that the order passed under section 14 relying on which the impugned notice of handing over possession was issued was not issued by the district magistrate. Stop. According to the petitioner, the said order ought to have been issued by the district magistrate and not by anybody acting on behalf of the district magistrate. Stop. It has been submitted that as the order under section 14 has not been issued by the district magistrate, comma, the same ought not to be acted upon. And it has to be treated as non-est in the eye of law. Next. Learned advocate representing the state respondents submits upon instruction that the order under section 14 of the Act was indeed issued by the district magistrate and the date for taking over possession of the same has also been fixed. Next. Learned advocate representing the private respondents submits that the private respondents are also the heirs and legal representatives of the deceased mortgager. Stop. It has been submitted that a partition suit has been filed before the learned civil court and the same is pending consideration. Stop. An order to maintain status quo has been passed by the learned trial court. Paragraph. Learned advocate representing the bank submits upon instruction that the secured asset has already been sold, has been put up in auction and sold. Stop. The sale certificate has been issued on 9th May 2024. Stop. Physical possession of the property was taken long back, not physical, symbolic possession was taken long back, and the bank is obliged to hand over physical possession to the auction purchaser. Stop. For the same, the bank took steps under section 14 of the SARFAESI Act. An order has been passed by the district magistrate for taking over physical possession on 9th July 2025. 9th July 25. With the help of, not help, in the presence of an executive magistrate. It has been submitted that the petitioner did not approach court with bona fide intention. Stop. The applications made by the petitioner before the tribunal in terms of the leave granted by this court was not proceeded diligently and the petitioner did not take proper steps before the tribunal on repeated occasions, for which the applications stood dismissed for default way back in January 2025. Stop. No steps have been taken to get the applications restored. Stop. None of the legal heirs of the deceased mortgager has sought to redeem the loan amount. Stop. None of the legal heirs challenged the auction process or the sale that was conducted and stood concluded by way of issuance of the sale certificate in May 2024. Stop. It has been submitted that huge sum of money is due and pending on account of the loan, and the bank has taken steps in terms of the act to recover the same. Stop. Learned advocate representing the bank relies on the judgment delivered by the Honorable Supreme Court on September 21, 2023 in CELIR LLP versus Bafna Motors within bracket Mumbai Private Limited and others. Wherein the court observed that, wherein the court, relying upon an order passed in the matter of Valji Khimji, এই সাইটেশনটা একটু দেখে নেবেন তো, এখানে সুপ্রা করা আছে, তার মানে আগে হবে, হ্যাঁ, পেজ 137, reiterated that once an auction is confirmed, the same can be interfered on very limited grounds, as otherwise no auction would ever be complete. Stop. Entertaining objections after the sale is confirmed should not ordinarily be allowed, except on the limited grounds like fraud. Like fraud. Stop paragraph. It has been submitted that the bank has taken steps in the matter in accordance with law, and the writ petition ought to be dismissed. Paragraph. I have heard the submissions made on behalf. I have heard and considered the submissions made on behalf of both the parties, and have also perused the materials placed before this court. Stop. It appears that the petitioner and the private respondents are siblings. Stop. The petitioner is a married woman.
Well, number 5 is the father of the petitioner.
Oh.
And others is my lord.
Father means we know this, the husband of the lady who died. Acha. Respondent numbers 6 to 9 are siblings. And the respondent number 5 is the husband of the deceased mortgager. ঠিক আছে, আমি বললাম তো she is married. She is a married lady. Petitioner is a married lady. And she is a resident of Kerala. Stop. The writ petition is being presented by her constituted power of attorney, who is a resident of Kolkata. Okay. The notice of handing over possession, impugn notice. Admittedly has been issued in favor of all the legal heirs of the deceased mortgager, but the petitioner. Stop. From the facts narrated herein above, it appears that the petitioner, since 2023, is prosecuting her case, and she is all along aware of the steps taken by the bank to recover the loan amount. In terms of the leave granted by this court to challenge the proceeding, to challenge the steps taken by the bank for recovery of the loan amount, she approached the tribunal for relief. But thereafter it appears that she was not diligent enough to proceed with the applications filed before the tribunal. Stop. The tribunal granted time on repeated occasions so that the petitioner could prosecute her case. Stop. Now, case which the petitioner failed to do. Stop. The tribunal did not have any other option but to dismiss the matters for non-prosecution way back in January 2025. Stop. Had the petitioner been actually aggrieved by the steps taken by the bank to recover the loan amount, the petitioner should have taken immediate steps to get the applications restored before the tribunal. The petitioner never bothered to do the same. Stop. The bank accordingly, as there was no restraint order on the bank to carry forward the proceeding for recovery of the loan amount, approached the district magistrate under section 14 of the Act. Stop. The district magistrate passed order for handing over possession in March 2025. The petitioner feigns ignorance of the same. FEIGNS, feigns ignorance of the same. Stop. Consequent to the order passed under section 14, notice to hand over possession was issued by the bank in June 2025, and the same was affixed on the wall of the subject property, disclosing the date for taking over possession. Taking over physical possession of the same, as symbolic possession was taken more than a year back. Now was taken in the year 2023.
My lord, 8th of June 2022.
What is the date of taking symbolic possession?
8th of June 2022.
Where do I get that?
But I have given the list of dates, my lord, serial number 3.
No, but the bank has
handed over the possession notice.
Yes, 27th of September 2023.
Yes.
Date of taking
I think it is from the
notice.
Yes.
8th September, 27th September 2023. ঠিক আছে? The property was put up for auction, and an auction and a sale certificate has been issued. On 9th May 2024. That is more than a year back, and the bank would be obliged to hand over physical possession of the secured asset. Now, of the secured property, which was put up for auction to the auction purchaser. The bank stopped here. The bank has accordingly taken steps to hand over physical possession of the property to the successful purchaser. Stop. What is this order in Sanjay Sharma?
Sanjay Sharma is also the auction can only be set aside on the ground of fraud.
The Honorable Supreme Court, in the matter of Bafna Motors within bracket Supra, has laid down in no uncertain terms that once an auction is confirmed, the same can be interfered on very limited ground like fraud, or else the auction would never be complete. Stop. In the instant case, no case of fraud has been made out. Stop. It appears that the bank took steps in accordance with the provisions of the Act. Stop. The petitioner, despite being aware of all proceedings initiated by the bank, has challenged the action only because of the reason that her name is not reflected in the notice for handing over possession. Stop. Paragraph. The petitioner has not come forward to redeem the loan amount. Neither has any of the heirs of the deceased mortgagor taken steps to redeem the same stuff. The provisions of the Act now the Act contains a provision for grant of compensation and costs, and also the tribunal has the power to return the secured asset to the aggrieved person if it is ultimately found that possession was taken over illegally. Stop paragraph. At this stage, no illegality appears to have been committed by the bank in taking steps to recover the loan amount. Stop. If the petitioner is genuinely aggrieved and is still of the and still submits that and still asserts that there is illegality on the part of the bank, then it will be open for the petitioner to approach the tribunal for necessary relief. Stop. No relief can be granted to the petitioner who appears to be an indolent litigant. Stop. The courts ought not to interfere in such cases where the litigant is the litigant does not approach the court with clean hands. Stop. The writ petition fails and is hereby dismissed.
Only one submission, my lord. If I approach the DRT, my lord, the DRT will consider without being the observations made by this court, my lord, will not be.
Certainly not.
My lord, kindly, my lord.
I have
specify.
recorded this observation after looking through all the documents, and then the next court will not.
Your lordship has granted me liberty to go before the DRT.
Yes.
So, my lord, when I challenge the section 14 order of the DRT, this order will be a bar.
Not at all.
Yes, because your lordship has already observed that section 14 order has been passed. And
Go and challenge only for the purpose of receiving compensation and costs and everything.
It then specifies that, my lord, at least.
Nothing.
With your lordship.
Your item number 4, I am for the petitioner.
I'm for the private respondent. Your Lordship, in compliance of your Lordship order dated 19th June, I have made application before the concerned PS to recover my ornaments and other belongings.
Now, the inventory was done, my lord, and
Then what happened?
Your Lordship, I have got most of my belongings, but there are some jewelries and cash that are yet to be recovered. All proceeding has been video recorded. Rupees 40,000 and 500 rupees cash has been recovered from one my almirah and another almirah of my mother-in-law, but key was with me. Police has not handed over the cash, and there are gold ornaments that are yet to be recovered. I have made
Yet
GD
to be
on the
recovered means
my lord, the thing.
the ornament is there inside the.
No.
Then where from will it be recovered? Take steps in accordance with law for recovery.
Lordship, a direction may be given or liberty to
No liberty is required.
made appropriate application for recovery.
Yes.
Lordship.
Yes.
My lord, if their submission is that, then my lord, we have also made one submission. Your lordship would remember that on the last occasion, they had made one submission that the lock and key of the wardrobes is not with them. But my lord, during the inventory only, they have approached us with the lock and key, and for the first time that was opened. So my lord, I had also made one complaint to the police station because they had been staying there for the past 3-4 years, and my jewelries were also there. So I had provided this list to the police stations, giving the order numbers and even the receipt of those gold ornaments, the jewelries and the cash receipts, and that has not yet been recovered because the lock and key was with them, my lord. But I understand that is not the ambit of this writ petition, so I'm not pressing on that particular argument in this point, my lord.
Right.
Last GD is also filed before the.
But be that as it may, my lord kindly keeps it in record that this is my complaint along with the annexures with the bills and all the other things.
Your Lordship, I have another submission. That is, the house was originally belonged to my husband. Thereafter, in the year 2021, it was transferred to my mother-in-law, and my mother-in-law has approached this honorable court for under Senior Citizen Act to vacate me. My submission is, Your Lordship, I have residence order. I have made application before the magistrate under Section 12 of the DV Act. That application may be heard on merit without being influence of this proceeding because I have residence order.
It appears from the submissions made on behalf of the petitioner, the private respondent and the state respondents that the petitioner is currently put back in possession. The petitioner has currently been put back in possession of the property which stands recorded in her name along with her daughter. Stop. Paragraph. The parties have certain grievance with regard to some jewelry and cash which was allegedly kept inside the almirah and wardrobes,
my lord,
of the room which was locked by the private respondent, and the keys of the room remained with the private respondent. Stop. Paragraph. The petitioner and the private respondent prays for taking back their jewelry and cash. Stop. Paragraph. It appears from the report filed by the officer in charge of the Patuli police station dated 8th July 2025 that an inventory list was prepared by the learned advocates of the respective parties. in the presence of the police officer, in the presence of the police officer, namely SI Dipankar Banerjee, who put his signature on the said list. Stop. A videography has also been made. Stop. Acha. As the primary relief sought for by the petitioner appears to have been allowed, accordingly, the court is not inclined to keep the writ petition pending any further. Stop. The writ petition stands disposed of. Stop. It will be open for the private parties to approach the competent forum with regard to their prayer for recovery of jewelry, cash, cash, or any other document or article in accordance with law. Disposed.
Lordship, prayer for residence order, Your Lordship.
Residence order, what will this court do with the residence orders? The court will not mention anything
Your
about
Lordship,
that.
that application may be disposed of expeditiously because I have been residing with.
This is not your writ petition. So prayer cannot be made by you in this manner and the court will not allow it.
Okay.
Next one.
I'm obliged, madam.
My lord, I beg to appear on behalf of BSNL, Your Lordship. May I be permitted to appear virtually, my lord?
Yes. Is the petitioner there? BSNL.
My lord, on the last occasion, Your Lordship will recall, my lord, they have, sought the liberty to file their exception to my report. My report is already there, my lord, with the records. My lord, even on the last occasion, they sought the liberty to file their exception. It was granted, my lord. Till date, nothing has been done on their behalf, my lord.
Very well. Today I'll make it, not today only.
Grateful, my lord.
My lord, this kindly see the last order passed by your lordship. My lord, very vital order, the 19th of March 2025. So Lord,
19th March 25.
lordship. My lord, there are the direction to release the the money in favor of the petitioner out of 10 serial 1 to 7. That has been paid in the morning, admitted. Now rest of the, my lord, kindly see the paragraph 5 in my lord 19th of March.
Yes, what is there?
My lord, that
Rest
is
of the
the
matter?
my lord, this the bill which has been, my lord, admitted by the erstwhile BDO pursuant to the order of this honorable court. And now that erstwhile BDO sought for fund. Subsequent, my esteemed friends, that means Bandobadda submitted that the 8 to my lord, the 10 serial, that bill is not available in their office. So now I have been directed to hand it over that bill that has been handed over. All bill handed over out of my lord 1 to 7
paid.
So
8,
now
9, 10 is still remaining due.
So now my lord, this kindly see, this is the CM program. I have been directed to supply.
Let me hear.
No, my lord, another submission. So my lord, the paragraph 5 of your lordship's order, that is the interest part.
Interest, I'll see.
Your
Yes.
Lordship, may I place the report?
Are you aware what happened to serial numbers 8, 9, and 10?
Lordship, I'm not aware of that, but we have paid 8,52,359 to the petitioner as of date. I am not aware. I have to take instructions and come back.
All right. Learned advocate representing the petitioner submits that payment in respect of serial numbers 1 to 7 has been made, however, without any interest. Next, the payment in respect of serial numbers 8, 9, and 10 are yet to be made. Stop paragraph. Report by the BDO, Mathurapur 2 Development Block, dated 26 June 2025. Placed in court by the learned advocate representing the state respondent is taken on record. Stop. Next. The matter stands adjourned till 29th July 2025. Stop. Balance payment in respect of serial numbers is 8, 9, and 10 shall be made prior to the adjourned date. Stop. The issue of interest will be taken up for consideration on the adjourned date.
Grateful to loss. Grateful to loss.
Item number 7, my lord. I am for the petitioner. We have challenged an order of the West Bengal Clinical Establishment Committee, my lord, Regulatory Commission. Your lordship directed us on the previous day to file an affidavit. It has been affirmed, my lord, but today,
I'm for the private respondent.
today there is some difficulty in. I have
Madam, what? He is not present. Right? You are present, so you please. Are you there in the panel?
I'm not there in the panel.
All right, you give. It will be recorded.
Your lordship directed us, my lord, to file an affidavit in this matter. It has been affirmed. If
Yes,
your lordship,
petitioner.
Today, but I couldn't attend personally because of some.
Unmute yourself.
I'm unmuting. The host is muting me. My lord, may I, my lord, file the affidavit tomorrow, my lord? Or if there is a difficulty, day after tomorrow, because tomorrow there is some disruption, traffic disruption might be there. Day after tomorrow, the affidavit has been affirmed. It is ready.
Why tomorrow there is some.
There might be some traffic disruption, but there is some, my lord.
Okay, ঠিক আছে. On the prayer of the learned advocate representing the petitioner, time to file the affidavit as directed video order dated June 2025 stands extended till 14th July.
Madam, there is also a direction to serve an advance copy upon the respondents.
Stop. Copy of the same upon the respondents. Stop. Released on 28th July.
My lord, I have already received. My learned friend probably hasn't.
I have not received any copy, my lord.
I'm for the respondent number 2 and 3, my lord.
I'm for the private respondent. We have not received any copy.
Video. Next.
Item number 8, my lord, I am appearing for the petitioner. Last occasion, this matter is relating the order of the insurance ombudsman, my lord. On last occasion, your lordship, it has been fallen from your lordship that whether the petitioner is agreeable to complete the tenure for the insurance, my lord. That is, which will be ending on 2026 December. But I have obtained instruction from my client. My client is ready to wait till 2026, my lord. Kindly record that tenure for 5 years should be end on December 2026.
No, that is already, they have already.
They have already, yes. That is the instruction.
No, that is not the instruction, no, my lord.
Oh, instruction is something else?
I'm telling you, my lord.
The award was the email that I had handed over to your lordship on the last occasion.
Right. On expiry of the lock-in period, the policyholder can commute a part of the total accumulated value in lump sum. Why a part? And the balance is necessarily paid in the form of annuities at the periodical intervals chosen by the author. In case the discontinuous fund at the lock-in is not sufficient to purchase minimum, and such purchase must be given as lump sum.
The policy in dispute is currently in discontinuous status and fund value under the policy is rupees 2,18,752.49 as on 13th June 2025. So this will increase on the date of maturity, has to be. So on the date of maturity, this will expire on 29 December 2026. So on that date.
Lock-in policy is still 29th December. The policy is for a longer period.
Yes, my lord.
No,
That
this is from 2021 to 2026, the 5 years.
No,
That is
come
the
to kind,
lock-in.
Yes.
number
Lock-in.
26.
But the policy itself is of a longer term. The petitioner cannot withdraw prior to 29 December 26.
My lord is saying with regard to the order passed by the ombudsman.
Your document.
Yes, my document. I am saying that it will expire on 29 December 2026. On the expiry of the lock-in period, the
Yes.
petitioner
Wait,
can
wait, wait,
commute
wait,
a part of the total accumulated value of. But let us not get into all this. We are asking the petitioner to come and implement. We are trying to implement the award of the ombudsman.
He has to come to court again. If your submission is to be taken to be proper. The policy where the petitioner's money has been invested
Right.
is for a longer term. It does not end in 5 years.
My lord will need not go into my instruction. Lordship will kindly direct them to comply page 26. To comply with page 26. We are asking them to come to us.
My lord, on last occasion.
Well, 1 minute.
See page 26. My lord,
Page 26.
Yes. You give us these documents, we'll comply with the award passed by the ombudsman. That's all. The
No.
matter ends there.
No, my lord, the order of ombudsman is different. There,
Yes,
where
that
is
is
my
why
agitation?
that is why I was just beseeching your lordship to take cognizance of page 26. Let them come and deposit these documents.
What is the period of this policy?
From 21.
No,
26 is not the period.
no, not is that is on page number 24, my lord.
What is the
That
May
is
I-
31, page number, that is paragraph, second last paragraph, observation and conclusion, page number
Listen,
24.
the petitioner wants to withdraw whatever is there on 26th December 2026.
Yes, my
But may I place the award? Taking into the account of the fact and circumstances of the case, the submission
Mr.
made
Dey,
by both parties.
it
But
is-
I'll just indicate during the course.
No, you are not getting the proper thing.
No, in the event the fresh single premium ULIP has been plan is issued on the life of the complainant, then it shall be under debt fund and a lock-in period of 5 years.
What is the period that has
Lock-in
been
period of
mentioned
5
on
years?
above paragraph? That is conclusion and observation. See, on 29 December 2031.
Where is it?
That is observation and conclusion.
Which
Just above the award, page number 24.
24.
Page number 24. Observation and conclusion.
The complainant took SBI Life Retire Smart Policy on 27 December 2021 with an annual premium of 2 lakh and premium paying 5 terms and maturity on 29. That was the scheme that he had opted for. Now he says that I do not want to proceed with this scheme any further. That is why the ombudsman directed us to turn this into a single premium policy for 5 years, which will expire on 26 December 2026, and that is what we are asking him to do.
And I kindly come.
But I cannot. But Lordship will appreciate. But the policy that he had signed for was for 10 years period, and for this 10 years he was to make an annual payment of 2 lakh. That is the observation and conclusion. Then what is the order passed by the ombudsman? That in the event the fresh single premium ULIP plan is issued on the life of the complainant, then it shall be on the debt fund and for a lock-in period of 5 years. So that is why we are saying that on to 29 December 2026, this will mature and he will be paid the amount.
You see your instruction. The instruction, the single page document.
Yes.
Right. At the top, you can see serial number 1. Serial number 1 at the top.
Yes, on the expiry of the lock-in period, the policyholder can commute a part of the total
Listen,
accumulated.
a part of the total
Lordship need
accumulated.
not go into this.
Right.
Lordship,
Because this is
no.
case.
Then what I was just beseeching your lordship. Then your lordship will direct us something. Because we are to comply with the ombudsman order. Because we have asked him to submit these documents, we'll comply with that. So in compliance with the ombudsman order, the policy will definitely expire in 2026 for a period of 5 years. That is the order of the ombudsman. See page 26.
Anyway, this is the observation of the court that you are reading it wrongly. You have to give something in writing before the court, wherefrom the petitioner will have record to show that on 29th of December 2026, he will be entitled to the entire amount that he has paid along with
The
interest.
entire insurance amount that will be.
Along with
Lordship will
interest.
kindly record that and direct me.
Yes. Learned advocate for the petitioner submits that.
My lord, one thing,
The
Lordship,
petitioner.
may I just say one thing? Lordship will kindly put this to take me instruction on this, because if my client somehow, my lord, there are other contingencies also, somehow do not really come up to that, then we'll contest the case. So Lordship will kindly keep that open.
আচ্ছা কি বললাম is agreeable to the lock-in period of 5 years as directed by the ombudsman, but the petitioner wants to withdraw the entire amount deposited by him along with interest on expiry of the 5 years lock-in period on 29/12/2026. Paragraph. The instruction forwarded by the SBI Life. SBI Life.
SBI Life.
SBI Life Insurance Company Limited.
Life Insurance
SBI Life
Company
Insurance
Limited. Implies that on expiry of the lock-in period, the policy holder can commute a part of the total accumulated value in lump sum, and the balance will be paid in the form of annuities at periodical intervals chosen by the policy holder. Stop. The instruction further mentions that for discontinuance fund value at the end of the lock-in period, in case the discontinuance fund value at the end of the lock-in period is insufficient to purchase minimum annuity, such proceeds may be paid to the policyholder or beneficiary as lump sum.
May I submit one thing?
Wait, the petitioner is not inclined to continue with the policy in any manner whatsoever after 29th December 2026, and the petitioner intends to withdraw the entire amount deposited by him along with interest on or immediately after 29th December 2026. Stop. The respondent company is directed to forward a written instruction to the learned advocate disclosing as to whether the petitioner will be permitted to withdraw the entire sum deposited along with interest immediately on or after 29th December 2026, as the petitioner is no longer inclined to continue with the policy.
Well, Lordship will also kindly record.
Released 8 तारीख 22 तारीख 22nd. 22nd.
Yes, my Lordship will kindly also record that if we cannot come to then matter will be decided on merits on the next date, because Lordship will kindly record that. Otherwise, I will be placing the decision as to the regard to the maintainability of the writ petition also.
এটা হবে না, ডাকবেন না।
এই যে
Grateful.
I'm for the state response.
I'll make it only not today.
Yes.
Then you are there. All right. But then union is also a party, I see.
I think the grievance of the writ petitioner has been redressed because the writ petitioners herein, they have been repatriated. That is my report and that is the dispute. Madam,
Are you aware?
Yes.
I am for the union.
Oh.
Baba.
Petitioner.
My lord, then lordship kindly make it.
I thought you were for the petitioner,
Then my lord, no.
not today. Eleven.
11, I'm for the petitioner, my lord, led by Mr. Jha. 11. I'm appearing for the petitioner.
Who is appearing for the petitioner?
Sorry, ma'am. Sorry. My lord, there is a direction, my lord, 16th May 2025.
Yes.
But we have not received any, my lord.
Instruction. I'll only adjourn for the day.
Lordship.
Yes, next.
Great.
There is a direction about me to file an affidavit, but I could not have kindly having 1 week time. My lord. There is a direction of
So prayed, my lord.
file an affidavit, my lord, I could
But
not.
then how many time will
My lord,
the
as a last chance, my
extension be
lord. Only
made?
1 week, my lord, as a last chance, my lord.
Then imposition of cost.
My lord, kindly. Only 1 week, my lord. Next Tuesday, my lord, let you, my lord, by the time I shall file.
Learned advocate appearing for the minority commission
Yes, my
Minority
lord.
commission. my lord.
seeks further extension of time to file the report by way of affidavit. Stop. As last chance, the time to file the affidavit stands extended till 18th of July. Released on 28th.
Deep down.
Exception may be filed prior to the adjourned date.
Great. But I am appearing for the petition. On the last occasion, your lordship directed to the state respondents to file a report.
Ghalib is appearing in the
File-
matter, lordship.
I filed the apply for certified copy, but I did not get. On 30th June.
Do you have any report with you?
Lordship, on the last occasion, updated report was supposed to be filed on lordship. I have one report, lordship.
What is the status of the certified copy? Is it there?
Lordship, I don't know exactly because lordship, I am not in the matter, lordship. The matter is going on Mr. Ghalib in court number 7, lordship. In page 2, lordship, there has been about page 2, para 6. Such record cannot be retrieved till date, lordship. In para 9, lordship, committee has been formed, lordship. And the last para, lordship.
The district judge has sought time to trace out the record.
And may I
And
get
lordship,
the
Anderson is requesting for 1 month
And
time for
give a copy to him. Please come. Peruse the report forwarded by the district judge Malda. It appears that steps are being taken to trace out the records of the partition suit. Stuff. A month's time has been sought for. Stuff. In view of such a report, hearing of the matter stands adjourned till 30th July. Stuff. An updated report shall be placed before this court on the
30th.
returnable date.
Lordship, one more thing, lordship. Mr. Ghalib is there, lordship. The matter is going in court 7, lordship. Can I the name
Mr.
of the-
Ghalib's name may be recorded.
Lordship.
Yes.
My lord, I am for the petitioner. As per my lord's direction, my lord, I visited the office of the registrar, my lord, on 4th July, my lord. My lord, unfortunately, my lord, my book number 4 has not been shown. Other books has been shown to me, book 3, book 2, but book number 4, my specific allegation is that in kindly come to page, my lord, my writ petition.
Hello, reporter copy no. Hello, reporter copy.
Writ petition, my lord, page 5, I have stated that will being book number 4 being such and such, but they have shown other books, my lord, excepting the book number 4. I have raised objection, my lord. They have received the objection. This is the copy. Kindly see, my lord.
Non-availability.
There must be
This
a
office is in the
book
process
number
of
4.
searching out volume number 19 from the year 1992. Volume number 19?
Yes, my lord.
1992 has
1992. Book number 4. Book number 4 never shown, my lord.
all right. Book 4, volume what?
19 volume.
Volume 19.
Yes. I have stated in my petition, my lord.
Yes.
Paragraph, page 4, paragraph 10.
Please come. It appears from the report
Well,
forwarded
may I
by
submit?
the Register
Well,
of
may I submit?
Assurances, Kolkata.
His prayer in the petition, my lord, his father executed a will.
He wants to see
No, my lord, it is not
certain
correct statement.
documents.
No, my lord, it is not correct statement, my lord. My lord, first, my lord, one petition was moved before this honorable court. He made an application. Your lordship kindly turn to page 34.
He
P9.
wants to see certain documents, inspect documents. Is there any problem?
Well, that is not his prayer, my lord, page 50. What is his application? Your lordship kindly see what is his application. Now he is coming with new plea.
In case he wants to inspect certain documents.
Yes, my lord. 90 volume 19 is not available at present. We pray before your lordship.
Yes, I'll grant you time.
Yes, my lord. Other volume, my lord, has been given to him.
Aha, he wants one book and you give him other book.
No, my lord, it is
What
not
is
correct
the
statement.
use?
He wants, my lord, the volume number 3712 of 1992. My lord, you must kindly turn to
Volume
page
number
50 of the
19.
petition.
Volume 19.
3712. You must kindly turn-
Volume cannot be 3792.
That is the will number, my lord, 1990.
Yes.
What is his application? Be noted certified copy of the deed number 3792 such and such is keep such and such. A file number, book number 1, 2, 3, and 4, which is suspicious not to get. Other volumes of my lord have been shown to
Volume
him,
4 has
excepting
not
volume number 19. We pray before his lordship.
Please come.
It is not readily available. We shall hand it over to you after my lord.
The
allegation against the petition by the my lord, petitioner is my lord,
dated
not
7th July 2025.
correct.
ये शुरू करलाम। That volume number 4, no, book number 4, volume 19 of 1992 could not be shown to the petitioner as the same is readily not traceable.
My lord, what is the my dear lordship? Once start to the page 4, last page of my report, R4. That is not the my lord will. He has also stated that it is gift, file, and power.
Whether it is gift, whether it is will, how are you concerned and how is the court
He has
concerned?
stated, my lord. Petitioner himself
He
stated.
may have stated something wrong.
Alright, madam, we shall
It is
find-
only the
after
book
obtaining
number
the-
and volume number. Finish it off.
We are ascertaining, my lord, after my lord. After
Yes. Book 4, volume 19.
Yes.
Page number?
এক জায়গায় এক এক রকম প্রেয়ার, তিন জায়গায় তিন রকম পাতা লিখেছে।
Book 4, madam, volume 19.
What is the page? A book contains number of pages. Now page 2 will be shown and you will say, I read page 22. What can be done?
Page number is not available.
How will you search the entire book? It's impossible. There has to be a page number.
Being number 3712/1992.
And that is the deed number you have
Book
stated.
number 4 being number
Paragraph 10 he has stated below.
3712/1992.
From the
Book number
petition,
certain
show the
number-
page number.
No page
Page
number.
number not mentioned.
Then how will you find out? You cannot go on searching the
Volume
entire
19,
book.
if volume 19 shows, then it
Volume 19 shown
Here it has not been mentioned volume 19. Here it is not been mentioned volume 19. Only they have stated will being book number 4 being number such and such of 1992. Paragraph 10.
file number is there, my lord. Registered
number
file,
তোমাকে
being
দেওয়া
file
হয়েছে।
number is there.
দেওয়া হয়েছে। সব ভলিউম গুলো দেওয়া হয়েছে excepting volume number 9.
volume 4, volume 19 of 1992. বুক 4 লিখেছেন আইভি ঠিক আছে ঠিক আছে the registrar of assurances sought extension of time for searching out the said volume paragraph in view of such submission comma hearing of the writ petition stands adjourned till 12th August 2025. Stop. The authority shall trace out the missing book and volume and intimate the petitioner so that the petitioner can go and inspect the same. Next.
Your Lordship, I appear for the petitioner, Your Lordship, in serial number 14, Your Lordship. This matter was taken up, Your Lordship, on 30th June, Your Lordship. This matter, Your Lordship, where I had made an application before the RBI for registration of NBFC. My application was rejected. Thereafter, I preferred an appeal, Your Lordship. The day, Your Lordship, the virtual hearing of the appeal was taken by the respondent number 1, Your Lordship, there was an error in the network. Immediately, we informed them and requested them to give us the next date of hearing. We gave the reminder letters also, which were not replied. Finally, Your Lordship, on 18th April, Your Lordship, we received an order of 17th April dismissing my appeal, Your Lordship. On the last occasion, Your Lordship, the respondent number 1 wasn't present. The RBI, Your Lordship, was represented, Your Lordship. We have served on all the respondents, Your Lordship, who
The
did not
union
appear on
appeal,
that
are
day.
you there? The petitioner wants a rehearing.
Reconsideration.
Yes, for reconsideration of the application. What is your submission?
From what it appears from the order, Lordship, the points have raised by the petitioner will all be considered.
But the petitioner was not heard.
So that I have to seek instruction whether it was what his.
Its submission is that there was a technical glitch for which the petitioner couldn't connect and hearing.
Instructions on that score.
All right,
Whether
please
they
come.
might not be had given
He has also given the reminder letters, Your Lordship.
The
They
petitioner
have not replied to any of the reminder letters. If Your Lordships kindly see, Your Lordship.
reconsideration of the order. A reconsideration of the application filed by the petitioner
My Lord,
for registration.
It is appeal.
Appeal.
Order, Lordship,
अच्छा
which may say
কি বললাম
initial order it was
কি বললাম The petitioner seeks reconsideration of the application. Filed by the petitioner seeking registration as NBFC. Stop. The prayer of the petitioner stood rejected by the competent forum, and the said order of rejection stood affirmed by the appellate forum. Stop. The petitioner is aggrieved by the same. Stop. Learned advocate for the Union of India is directed to take necessary instruction. When can you come back? 2 weeks? 22nd.
Your Lordship, only one thing, Your Lordship, we had given even the reminder letters on 20th January and 13th February, no reply. On 17th April, we received the order, Your Lordship.
Very well. Please go through it and see whether there is any scope for reconsideration. Yes, next. কোনটা কেন কি মিসপ্রিন্ট হয়েছে
Miller, Lordship, and see the last order, Miller, we have complied the order of Lordship, Miller. There's a payment with regard to Miller,
Leela Diagnostic, my lord. The payment has been made.
Has payment been made?
56,510 is still due and payable. Number one.
Count of?
Same. My claim was near about, my lord, 24 lakhs 39,388. They have paid, my lord, 23 lakhs 82,000.
And the rest possibly must be tax or something?
Yes, my lord. Because in this report, my lord, you will find, my lord, in the page 2, my lord, it has been mentioned, my lord, certified that out of 24,39,289 received during the year so and so, Murshidabad from the so and so. Thereafter, my lord, on account of unspent balance of the previous year 24-25, a sum of rupees 24 so and so, 4 lakhs 1,000 so and so has been utilized for the purpose of Leela Diagnostic payment, which is sanctioned, and that the balance of only 7,781 so and so remaining unutilized till now. So, my lord, the entirety, that 24 lakhs and odd, my lord, after deduction, my lord, 23 lakhs and odd has been paid to him, my lord.
Lord, I have another prayer, my lord. My lord, can you text, my lord, page 15 of my petition?
No, you said 56,000 is due.
Yes.
Here it says 7,000 is due.
Yes.
They are saying, my lord,
That's why that is my calculation sheet.
calculation is not with me.
That is
Overall calculation I have made, my demand was, my lord, 24,39,388, paid, my lord, 23,82,878. But this calculation, my lord, I have no knowledge. But another thing is this, my lord. My lord, this is the payment, my lord, which is due and payable since, my lord, 2021. Now 21. Now, my lord, they are paying in, my lord, in the middle of, my lord, 2025. Now, I paid for interest, my lord, in my petition itself.
That's what I'm saying, my lord. Mr. Tiwari, let come up with.
No, that will be bad. Order to rule 2. That will be bad and order to rule 2.
It cannot be done.
I know, my lord,
It has to be done in this matter only.
But, my lord,
Otherwise,
we appreciate that, my lord, this much of amount, whatever is due.
so whatever is due, it is his legally due, no legal due. It's not that
there
you
is some
giving
that's
some.
that's what, my lord, payment has, there is some delay in payment. I agreed with that, but kindly, my lord,
Let your officer come up and say the reason for the delay, and then only it can be seen. Otherwise, why will a person who is providing service to the hospital, government hospital, receive the fund at such a delayed point of time? Acha, please come. You hand over this to him so that he can also. Acha.
এই তমাল কোথায়? তমালের কাগজ আছে একটা? তোমাদেরকে এটা দিয়ে দেন।
এটা দাও কপি।
From the document handed over to the court by the learned advocate representing the state respondents, it appears that a sum of rupees 23,82,878 has been paid to the petitioner. Only in June 2025, the petitioner submits that a certain amount is still due and pending. Prayer has been made for grant of interest on account of the delayed payment being made. The payment was due in the year 2021 and the same has been paid in June 2025. The authority is directed to make necessary calculation for payment of interest on account of the delayed transmission of funds. Next, the interest shall be calculated on the banking rates. And a simple interest shall be calculated. The interest column to simple interest shall be calculated on the banking rate. Release the matter for further consideration on 12th August 2025. The interest that will be calculated and the amount that is due and payable.
According to me, my lord, nothing. You can record that, my lord.
Shall be cleared prior to the adjourned date. The learned advocate representing the state respondents that all dues of the petitioner have been cleared and there is no further due as on date. ঠিক আছে?
Lordship.
এটা আগে বসবে।
Which?
হ্যাঁ, submits. Yes.
Get lordship.
Deep lordship.
Yes.
2 নম্বর প্যারাগ্রাফ করে বসবে।
On behalf of the petition.
Yes.
My lord, this the pursuant to your lordship direction on 1st of July, I have already served the copy and now new learned advocate. Now, my lord, is kindly come to order dated, my lord, the 17th of June 2025. So now the petitioner before your lordships come before your lordship, they are the below poverty line category. Their house has been destroyed. They applied for my lord, financial assistance. So now.
Yes, what is your
I have my report, my lord. May I place it before us? Lord. And let's see, initially the petitioner claims, my lord, relief under the for the cyclone affected person. Then, my lord, he shifts, my lord. He says, my lord, my lord, will kindly see the phrase, my lord, at page 9. Lord, he says, my lord, give me the benefit under the housing schemes of the Pradhan Mantri Awas Yojana and subsequently, my lord, Bangla Awas Yojana. My lord, will kindly see, my lord, my report which says, my lord, total, my lord, there are 17 petitioner before lordship. 5 in the petition and your lordship has allowed the can on the previous day, 13 there in, my lord. So, my lord, will kindly see the penalty made paragraph of this report, my lord. I've stated the giving the specific numbers, my lord. In the paragraph 1, my lord, these people are not entitled to because they have pakka construction, they have their own houses. So in terms of the scheme, my lord, they are not entitled to. Secondly, my lord, paragraph 2, my lord, kindly see, let's say 5 of these persons out of the 70 are entitled to, but their name does not appear in the beneficiary list. Lord, created in the last survey, which was done in 2018. What can be done, my lord? Of course, my lord, as we find they are eligible, my lord, we can recommend their name in the next list that is to be prepared by the PNRD department.
Any idea when the next list will be prepared?
My lord, I don't have any.
My lord, may I say one thing in addition?
1 minute, 1 minute.
Lord, I have
And
have that. Any, my lord, earliest possible, whenever that list will be prepared.
All right, 1 minute. Tell me the 2018 list that has been prepared.
Well,
whether the payment has been made to the recommendees.
That also, my lord, I have to comment. That, my lord, does
From
not in any way.
2018 till
My lord,
25.
Your lordship knows, my lord, the 2018, my lord, there is a problem with the implementation of this particular scheme. That is the reason, my lord, Bangla Yojana has to be brought in. But there is some issues with the central government.
Whatever. These people whom you have found to be eligible.
My lord.
They have lost their homes in the cyclone or something?
No, they did not lose their home in the cyclone. Cyclone that's my specific case, my lord, specific instruction. The cyclone did not affect this particular cyclone, my lord, did not affect much West Bengal. So they did not lose their home due to this cyclone. But they are, what is my case is, my lord, they are otherwise eligible for getting housing benefits
Bengal
under
Awas
the
Yojana scheme.
Awas Yojana scheme. So whenever the next list is prepared, my lord, we'll immediately recommend their name to the PNRD department, and whenever the list is taken up, that is to be.
And where from did you get to know that 12 petitioners are not entitled? Did you conduct an inquiry?
BDO has conducted a discrete inquiry. I have even the photographs, my lord, will see, which, my lord, annexes the
houses.
I want, my lord.
দাঁড়াও না, সব পাবে তুমি। Well, I did not place clause 3 of my report, which says, my lord, one of the petitioners, serial number 4, my lord, could not even be traced out.
Yes.
My lord, this the kindly see the payment, kindly come to page 25. I have given the paper cutting.
This does
Though
not work.
does
my lord.
not work. My lord, let them to come with the evidence because of the persons whose name are not included in the the list. They have given the benefit. I have the list of the.
That is a different case altogether.
My lord, I have stated herein because of our name intentionally at the time of my lord, the verification they have not included. That's why the this
that has
person, the
not been
reason based
included-
behind back, my lord, I know, my lord. That's why I have come before the my lord.
Page, which page?
Kindly come to page 25.
25.
আবাসের প্রথম কিস্তির
Do not go to these paper cuttings.
Now, my lord, this my
I
lord,
think that
What is your case? When you claim benefit is one thing. Somebody else has been given the benefit by depriving your claim is another thing. What is your case?
my case is this, my lord, I applied before the district magistrate.
Yes.
District magistrate directed to the
When?
my lord, this the I applied on my lord the 14th of my lord the November 2024.
24.
it was created.
No, my lord, this initially we have given the my lord the benefit of my lord the some my lord the temporary benefit like my lord triple etc. by the provided by the Gram Panchayat in 2024 May.
All right.
Then the during the pendency of the writ petition, on considering our application, DM directed to the jurisdictional Gram Panchayat to again, my lord, this inquire the matter.
Yes.
6th of December 2024, my lord, they found, I have placed this, my lord, the inquiry, my lord, the stated, my lord's memo number. They are found out of, my lord, these 35% applied jointly. Out of 35, 25 are eligible. We come to know. So now,
Where from did you get to know?
my lord, this is the report from the, my lord, the jurisdictional Gram Panchayat.
Where is the report?
I have stated, but that report is not served upon me. That report submitted to the BDO.
Yes.
BDO did not inquire the matter. My lord, Gram Panchayat, my lord, the
Video will do it through the Gram
Gram
Panchayat.
Panchayat. So now, my lord, the 6th of December 2024, pursuant to the direction of the district magistrate, what reports has come, I don't know. I have not been handed over the report. So that report is very vital because of the second time inquiry report.
First time inquiry report is not there before the court and you say this is
No,
second
I have stated
inquiry.
the memo number.
Your statement will not do.
No. In considering my application, memo number, BDO, DM again directed to. Kindly see the my page 15.
Please come. The petitioners.
Now at this juncture, the petitioner will outside.
Petitioners seek relief under the Bangla Awas Yojana. Stop. The block development officer has caused an inquiry and has found that 12 petitioners are not entitled to get the benefit under the rural housing scheme. But the balance 5 will be entitled to be considered in accordance with this scheme. Stop. The last list for recommendation of beneficiaries was prepared in the year 2018. Stop. The additional district magistrate and the additional executive officer of the South 24 Parganas Jila Parishad has forwarded an undated report to the court, wherefrom it appears that the names of the eligible petitioners will be forwarded to the Panchayat and Rural Development Department for consideration. Stop. One of the petitioners, namely Saidul Peyada, son of Samid Paik, could not be traced. Stop. The petitioners who have been found eligible are Tuktuki Paik, serial number 2, Tuktuki,
One report.
Moidal Paik, MAIDUL,
গেলেই আমার সুবিধা হবে।
আচ্ছা,
I will kindly mention the
Hassan
petitioner number that has the details.
Hassan Purkait, Jamuna Haidar, সালেম পাইক
গরিব লোক
কতগুলো বললাম একটা দুটো তিনটে চারটে পাঁচটা পাঁচজন হ্যাঁ have been found eligible for the benefit under this scheme. Stop. Inquiry report forwarded by these state respondents be retained with the records. Stop. Let a copy of the same be handed over to the learned advocate representing the petitioners. Stop. The writ petition stands disposed of by directing the
I leave may be granted because of that. I have
by directing the
Secretary Rural Development, Panchayat and Rural Development.
block development officer is not a party. The subdivisional officer is a party.
I will kindly put in appropriate authority will take care, my lord.
Malad, this leave may be granted to add.
Acha.
Thank you.
Difficulty becomes when
No,
it
we'll-
comes in contempt.
No, we'll take care.
It becomes very difficult
We will
to
take
get
care.
the order executed.
And your lordship will not want something, we ensure we are my lord's officer, my lord, immediately I shall ensure.
Acha, কি বললাম?
I don't mind if your lordship adds, but even otherwise I can take care.
By directing the concerned officer in the office of the district magistrate, South 24 Parganas, to make necessary recommendation in favor of the eligible petitioners for enlistment of their name in the list of beneficiaries under the rural housing scheme.
In the upcoming list, my lord will kindly indicate something.
In
on-
the list to be prepared in
I'm
future.
grateful, my lord.
ঠিক আছে? Writ petition stands disposed.
We are grateful, my lord.
My lords, any time limit.
What time limit? They will include now when 18 payment has been made or not, nobody knows.
Other person are getting, my lords. They, because of their favor child.
Under which list they are getting?
My lord, this
Prior
no subsequent. I have the list, but I cannot produce because this is the unofficial document.
then a fresh cause of action that X is getting and I am not getting. In
Yeah,
terms of
This is my lord the not favor child. That's why my lord is.
petitioner,
I petition. This one.
where is the petitioner?
And the petition.
Yes.
The private response. My lord, last occasion, pursuant to your lordship direction, my learned friend has my lord, handed over the copy of the exception. Now, my lord, this is regarding the issue, my lord, my claim to uproot the tree adjacent to my boundary wall, which is affecting or damaging my property. This is the issue. Now, my lord, the report says on 10/6/2025, pursuant to your lordship direction, an inquiry was held. A
What
report
does
was
the report say?
My lord, kindly see the second paragraph. It's very important, and then the photographs.
Unfit as a coconut and bottle. Although the damage is visible, the cause visible on the surface as you still with the mango tree is really one. The roots may cause damage to the construction of the
damage
petitioner in future.
And
There
my lord,
is a
then my
chance
lord,
of
kindly see the
construction
photograph.
damage.
Kindly see the photographs. Next page thereafter. One page.
Let me understand. What is the authority thinking of if there is a chance of damage being caused to the construction of the
But I have-
petitioner
I have
because
filed
of the root?
exception. My lord.
I'll hear the experts.
Yes.
Neither you nor you are the expert. The expert is here.
Penetrates.
Yes.
And in that event, there is chance of crack.
There is, yes, this is what your report says.
Yes.
What is to be done?
Then, my lord, overburdens have to be lifted. See the root, diversion of the root. Otherwise, it cannot be located.
I did not follow you.
Digging the earth,
Yes.
root has to be found out.
in which direction it is going?
No, the report says the tree and the boundary wall is only 1 foot.
Only 1 foot.
Only one.
Developed in the boundary wall.
Yes.
Yeah.
Boundary wall is not his boundary wall. Her boundary wall.
It's my boundary wall.
Assuming whoever's boundary wall it
Yes,
is, if it goes inside his
It is
portion,
not saying so. Crack has been developed because the boundary wall was constructed on
After its
state land.
submission, I will submit.
Because
assuming so.
it was 1 feet, thereafter another it has been constructed. So the boundary wall is horizontal. It's not vertical. If it is from the pictures, it will appear. And the first opening statement of learned friend is that he wants uprooting of the trees. That is not allowed under the law. I will show you.
The court is not concerned.
Law.
Listen, the law cannot be used in such a manner
Yes.
that it is going to damage his structure.
My lord, he
You
cannot
just
pray.
don't have any right to damage somebody else's structure.
Not being damaged. That will be a humble submission before lordship. The report also doesn't say so.
There is a chance of a damage being
That is
done.
hypothetical,
This is
which
what
I
the
have
report
challenged
says.
without any material and
Damage already took place, which it is
However,
reflected on the photographs taken by the expert.
However, no visible damage in the septic tank area or any other construction of the petitioner could be observed with bare eyes. That is paragraph 2. Last paragraph is distance between the mango trees and the boundary wall is 1 feet and the distance between
It
the
is
coconut
your tree. Keep it in such a manner, maintain it in such a
Roots
manner.
cannot be
so that
mallow
it
trimmed.
can
Roots cannot be trimmed. There is
Then
no
it will
provision in law. I have trimmed the branches, which I have on the first date said that yes, branches has to be trimmed. It was my statement which has been recorded in your lordship's order. In lordship in the first order has also recorded that the trees cannot be felled. That is as of today. Now it comes out. This is his main prayer. He wants my trees to be uplifted, which is punishable under the law.
listen. By uprooting your tree, he
Yes.
will not gain anything.
He is saying so.
Will he gain anything?
My lord,
What can
he's-
be the
that
mens
is
rea?
prayer.
What can be the mens rea?
Well,
He
as
wants
of
to
today, well,
protect
we have
his
to-
structure.
Not other.
His idea is to protect his structure.
Yes.
It is your tree.
It is
remove
not.
it.
It is not her structure which is being destroyed because it is 1 feet. 1 feet from the boundary wall. Thereafter, there is a mandatory open space. Septic tank is far away. And my lord, these things. First is my lord, these things cannot be decided in the writ petition. Second is he wants felling of the trees, which is not allowed under the law.
Will the expert please suggest what is to be
Expert
done?
cannot go outside the law. It is 2008
Stop.
Act, 2007
I
Act.
want to hear the experts.
But kindly also grants me
what
opportunity,
does
my lord.
your
So how can
authority
we-
say? How it can be resolved?
Can be resolved by seeing as to whether which direction the root has penetrated by lifting the overburden, which they are not
They are not.
agreeable.
They are not agreeable.
Who is not agreeable? I am agreeable. Oh,
Private respondent is not agreeable.
I am my part. There is some rubbish that can be removed, but I
With-
cannot take the
with due
responsibility of
respect,
his part.
with due respect to my
she
learned
wants
friend,
to
may I
uplift
submit one
because
thing,
The
Milord?
entire thing is
My lord, the
concretized.
report says as well as the
Entire
pictures
thing is
taken at the
concretized.
time
I
of
have
inspection
pictures. I
reflects
have also
the
pictures.
damage already been stated.
Why
Is in 1 feet distance. There is no other, my lord, the gap is there, my lord.
Why is it not, my lord?
Is there?
May I just place the law? Lordship,
Whatever is to be done, please do it, and the parties will cooperate to ensure that damage is not caused to the
My lord,
My lord, may I
root
just place-
trees should be uprooted, otherwise, my lord,
May I-
which will
may-
cause
may I-
damage because it will
cannot
enter
be
into my
uprooted.
septic tank and the, my lord, the reservoir.
Does it septic
This
tank
reservoir.
is not required?
Their land, they must
Yes.
self dig off the ground
yes.
by digging the portions to see where the root is going. There is section 5, my lord, say so.
Yes.
My lord, may I just
Whatever
kindly
is
take-
required to be done, the parties will do.
My lord, kindly may I just place section 5(4)? My
Yes.
lord, kindly takes up, my lord. This is under the West Bengal Trees Protection Act 2006. May I একটা বই দিন?
My lord, আমি দিচ্ছি, Dear lord.
My lord, first kindly, my lord, seize your lordship's order dated 8th April. Lordship has been pleased to hold, but that there will be no felling of trees. It is made clear that the trees are not required to be felled. Now, my lord, kindly sees the definition of felling of trees. Section 3, subsection 3, 3.3, yes. Felling of tree means cutting, grinding, such and such, uprooting or damaging a tree in any manner. My contention is that if the roots are, my lord, hurt, it will be damaging a tree. Now, my lord, kindly sees who can fell a tree. Paragraph 5, section 5. A competent authority on receipt of an application from a person to fell a tree or otherwise dispose of any tree for such purpose as may be prescribed, and on being satisfied with regard to the legality of the documents towards the proof of ownership of lease of the land on which such tree stands, and after making an inquiry in such manner as may be prescribed, grant permission. So therefore, if there is to be felling, there has to be permission from my side because the tree is in my boundary. The authority cannot say, in fact, no one else can make an application also. And my lord, if it is done, then it will be attracting penalties under section 11. Whosoever fells trees or causes to be fell a tree or cut, uproots, otherwise dispose of any felling tree in contravention of section 4, there is a provision for penal action. Rules are also so. Rule 4 is the permission for felling trees.
Expert report is reflects that my lord, damage has been started.
Totally erroneous.
My lord,
it is on.
We have to believe on the expert report. And but the photograph says that damage has been started.
It is says.
Let me submit your completion.
May I just place the report also?
Please come.
Well, may I
unless
just
until the
please,
trees are uprooted, my lord,
takes up the last
will cause damage to my property. Even there is a septic tank, there is a reservoir. Yes.
Yes.
Right hand side pictures.
Top. And it is not the first picture. Towards the top, my lord.
Yes. Yes.
The boundary wall, which is visible, arrow has been given.
My lord, cracks are shown around the two trees. The portion surrounding the trees.
Next, my lord, bottom tree.
No other portion.
Mango
All are
tree
creek.
is 1 feet boundary wall. Have you lot seen?
Some roots of mango trees is going alongside with the boundary wall.
Page 7, isn't it?
Report.
There are four photographs.
Yes.
What?
Page 3. 1, 2, 3. After completion of the report, then the first page photograph.
Yes.
The report of the divisional chief conservator of forest unit was 12th of June.
No, this is the exception actually. Yes, some cracks on the boundary walls.
That is around the trees. That is around the trees. No other portion is crack is been shown.
Oh. Yes.
Bottom of the boundary wall and mango tree forty.
Yes.
Boundary wall is visible. Boundary wall.
Visible.
Then, my lord, kindly see. Some roots of the mango tree is growing alongside with the boundary wall.
Right.
Next picture will give clear indication. They are coming out alongside with the boundary. As you have said, unless the overburden, both petitioner and the respondent, private respondent, they are to my lord.
No, the private respondent will not cooperate.
No, no, I
This
have
is very
cooperated.
sure.
I have cooperated. It is,
No,
it
the
is at my
petitioner-
expenses, the petition, the trees have been trimmed.
It is your tree, it's your expense,
I have
somebody
trimmed,
else will.
I have
So it's
cooperated.
no use
Past
saying
order will show that I am cooperating.
petitioner has to show to your officer as to whether these routes are going inside his area or not.
And my lord, particularly, one place that is no speed.
Septic
yes.
tank and the
Uh-huh.
Between the boundary wall and the septic tank, which has to be.
And my lord, septic tanks as of today are of no use. That is the different thing altogether. There are
in use.
septic
Please
tanks
come.
and reservoir, my lord, these are, my lord, kindly also, my lord, takes note of, my lord, my submissions.
The
Cannot be failed.
Grievance of the petitioner that the roots of the tree planted by the private respondent is damaging the septic tank of the petitioner
As well as the water reserve also.
and the water reservoir is yet to be resolved. Stop paragraph. The report of the forest report of the chief conservator of forests
Well, in fact, given by the divisional forest officer,
enclosing the report of the divisional forest officer.
Of the range officer.
Range forest officer appears to be a non-conclusive one. Stuff. It mentions about a chance of the structure getting damaged because of the roots of the subject trees. Stop. To actually ascertain as to whether paragraph away any damage has been caused or not. Further inspection is required. Stop. The petitioner and the private respondents are directed to cooperate with the officers of the respondent authorities so that a proper picture can be taken as to whether the roots are causing or may cause damage to the structures of the petitioner. Stop. Next. The parties may be required to lift the earth to so that the roots can be seen. Stop. The respondent authority is directed to issue appropriate notice to the parties, intimating the course of action to be taken to solve the problem. Stop.
The earth within their respective boundaries. I will be lifting my. Kindly adds this one.
Release the matter for further consideration on 12th August 2025.
Well, kindly makes a clarification to this effect. I will not be paying for hers, well, she will not be paying for us.
Call the next
Respective
one.
boundary, well, kindly makes this clarification. Well.
May I get back the book, my lord?
Yes, take back the book, please.
Item number 19.
The appeal was
Led by Mr. Bandhavata.
the appeal was taken up on 2nd of July 2025.
The issue has
Order
been,
was not interfered.
issue has not been resolved.
Issue has not been resolved.
I thought you all will get it resolved over there. And I would be spared the pain.
Lord, this order has not been interfered with.
Happy to send it back to your lord.
So what is to be done? It has to be heard.
Is to be heard, but my lord, in the meantime,
Hmm.
the contempt petitions are to be, my lord, they should take their normal course, because this is not a case of inherent lack of jurisdiction otherwise. This is a case of whether alternative remedy would apply or not. Whether that will be a case of self-imposed limitation, but not a case of lack of jurisdiction.
Whose lack of jurisdiction?
Your lordship, they challenge this order on the ground that petition is not maintainable. There
All
are
right.
other remedies available.
All right.
Now, my lord, the matter has been remanded back to your lordship
Yes.
for examining all the issues.
All right.
In the meantime, your lordship is also in session of the contempt petition.
Right.
Your lordship has been pleased to pass an order on 19th of May. The last effective order was passed on 19th of May. Now, my lord, the petitioners before lordship are facing hurdles day in and day out, and in an aggravated form, because my lord, now we have stirred the hornet's nest. Once we have stirred the hornet's nest, your lordship knows the consequences. Two petitioners had to withdraw the writ petition because of the tremendous pressure. They will not say so. We don't want them to say so. We don't want them to face the wrath of the high and mighty. But what is important is that now in the contempt petition, I beseech your lordship to issue rule.
All right. 1 minute. Thing is, what was the submission before the appeal court that this bench did not have determination?
Not determination.
Alternative remedy.
What is the alternative remedy according to the
As states
respondents?
appeal, we could not. I said, my lord, that without
States
making us
appeal.
party, my lord, I sought to intervene. Because, my lord, the contempt application, my clients have been implemented as a party.
All right.
So although, my lord, the honorable single judge I submitted that did not proceed with the contempt.
All right.
So far. Now, my lord, the question is allegations have been made.
No, I want to know as to what exactly was the ground for appeal.
They said that their submission was that it's an interest, private disputes. But
Writ court should not interfere.
Writ court should not interfere. That is the simplicity submission. Now, my lord, one thing, my lord, before they submit, my lord, your lordship is aware that in the first writ petitions, I filed an application under Order 1, Rule 8, my lord, for moving and representative. But that application has not yet been disposed of. I'll be praying that that application be disposed of, because there are other technicians, my lord, who have been regularly prevented. In fact, all these 14, whoever tried to, my lord, go for any productions, my lord, at the last date, my lord, no technicians comes because of the restraint of their respective associations. Now that has been done at the behest of the respondent number 5. It is, my lord, it is apparent because there are WhatsApp messages, my lord. I have all these scripts of messages, my lord, which says because we are under pressure of our guild. My lord, I have those messages. I can produce by way of supplementary affidavit. None of them, my lord, now whoever, first Sudeshta Rai, then King Shuk, then lastly Anirban Bhattacharya. It's his music video even stopped. My lord, nobody can work because they are not coming in front. It's all there in the, my lord, WhatsApp group or in through the associations, my lord, through the presidents and secretary. All are chosen by the president.
By the way, there was a direction possibly upon the state authority.
Yes, that direction has not yet been complied with. The 3rd April order.
Right.
That has not been complied with.
Why has the secretary?
3rd April secretary ke boleছিল না consider করতে
16 July, my lord, at 4 p.m.
Why did you wait for so long?
My appeal was pending, my lord.
Appeal was filed, but there was a delay of around 72 days, 48 days.
Order was 2 तारीख.
2nd of July, I can see the order is here.
Yes, my lord. The 16 July, my lord, the hearing will be conducted.
And did you issue notice to all the parties? Thereafter, one will come and say notice was not given.
Others will be issued, my lord.
When?
In the meantime.
You give me a sample copy of the notice?
I have it.
No notice has yet been received by us. But even today morning, no notice has been received.
None of the parties know that the date of hearing is fixed?
The yesterday's notice. Sorry, my lord.
No, I'll not look at any soft copy.
The notice is in the cloud, my lord.
How soon will you issue these notices? How soon will you issue the notices?
2-3 days, my lord. I have to take instruction, my lord.
A notice, what is the date of the notice?
7 July, my lord.
7 July. That means only yesterday. Because the matter will appear in the list today, you've prepared the notice.
I did not pay, my lord.
You means, see, there is nothing personal over here. You means your officer. prepared the notice, maybe today morning, and antedated it to 7th. I will record that 16th is the date of hearing, and it has come from you,
Yes.
so that all parties get notice. Have you followed?
Yes.
But order 1, rule 8 may be allowed.
Who has issued it?
Yes, but
Who has issued
Who are
this
you?
notice?
Additional secretary and ex officio
Please come.
director of claims.
my lord, my application may be allowed, my lord,
Learned.
under order 1, rule 8.
Learned advocate representing the state respondents submits upon instruction that a notice dated 7th July 2025 has been prepared and will be issued to all the parties, informing that 16th July 2025 is the date fixed for hearing before the Secretary, Department of Information and Cultural Affairs. It will be heard by the Secretary?
Yes.
Heard by
That was the
Secretary?
direction, my lord, 3rd
Yes.
April direction.
Heard by the Secretary. The issuing authority is the Deputy Secretary or the Additional Secretary.
Additional secretary.
But then it will be heard by the Secretary because that is the direction of the court.
There is
What
direction-
does it say?
It says, madam, the hearing will be scheduled on 16th July. madam.
Before whom?
কল্লোলদার কাছে বোধহয়। না না
But
Nothing mentioned.
The place is mentioned Robindra Sadan Conference Hall, my lord. Place is mentioned.
But then the authority. আচ্ছা আপনি লিখুন তো কি বললাম? Hearing has been scheduled on fixed on কি লিখেছি? 16th July 2025. Stop দিন ওখানে। Before the লেখা নেই order এই নোটিশে, ঠিক আছে? For hearing stop. The court vide order dated 3rd April 2025 directed the Secretary, Department of Information and Cultural Affairs to take the hearing. Stop. The hearing shall be conducted strictly in terms of the court's order. Stop. It will be open for the Secretary to hear all the necessary parties and ensure that the issue faced by the petitioners are resolved at the earliest. Stop. The right to life and livelihood, carry on trade, practice and business shall not be interfered with by any party whatsoever. What is the other submission?
Along with this right to carry on business and profession, freedom of expression, because film industry essentially is the freedom of expression guaranteed under 19.
How can this authority say what to express? It is your freedom.
No, freedom I am unable to express because I am unable to make the films. I am unable to make the films. I am unable to undertake.
Which goes on to show that you are unable to carry on business.
Yes.
So I will not include freedom of expression over here because that will lead to further complications. Let me see what comes. Thereafter, I'll see. Paragraph. All the parties are directed. Now, as the date of the hearing is disclosed by the learned advocate representing the state respondents and recorded in the instant order, all the parties will participate in the hearing process irrespective of the fact whether any further notice is issued or not. Stop. The fate of the hearing shall be made known to the court on the returnable date. List on 23rd July 2025. Stop. In the interregnum, the secretary shall ensure that the fundamental rights of the parties are not infringed in any manner.
Only thing,
আচ্ছা, এর উপরে একটা প্যারাগ্রাফ লিখুন তো। The order dated 2nd July 2025 passed by the Honorable Division Bench in Mat 792 of 2025 with এই সবকটা নাম্বার একটু লিখে নেবেন।
One contempt
Placed in
application.
court be retained with the records.
One
One minute.
contempt application is not appearing today, my lord.
Give the number, it will
I'll-
appear.
CPN 773.
Yes,
There are certain parties in the contempt application who are naturally not made party to the litigation. It was easier for them to get the order without that. When your lordship has directed all parties to be heard, your lordship, would it be your lordship pleasure to add that parties in the contempt also? Kindly add that, so I want to get a hearing.
যেখানে all parties বললাম সেখানে all parties in the writ petition and the contempt application.
Yes, yes.
Another prayer.
One language,
Another prayer.
Own language.
Millard, subject to correction, Millard. Since specific the choice of words, Millard, in the order, Millard, reflected that the issues must be resolved. Now, Millard, the resolve means, Millard, that it has to adjudicate, Millard, kindly sees that it has to be adjudicated in accordance with law. Resolved means, Millard, kindly have the charity to consider.
Yes, sir. Submission, what is your submission?
My submission is that the issues raised by the parties or, Millard, the petitioners may kindly be adjudicated, decided in accordance with law. Resolved means, Millard, that he cannot impose himself on me.
Try to find a solution.
He has to find solution.
You are anticipating things.
No, Millard. Anticipation, Millard, stands on the floor of reality. Anticipation, what we are apprehending, Millard. First of all,
The authority has not resolved the issue.
and Millard,
Another prayer, my lord.
Millard, never, Millard, possibly your lordship, Millard, while
Millard,
passing
kindly-
orders, Millard, in any matters, directing the adjudicating authority to decide in accordance with law. In accordance with, suppose, yes.
This in accordance with law remains silent. Does it give any right
Resolved
to the
means they have
authority
that
to-
means, Millard, resolved means, Millard, the dispute raised by them, Millard, indicating without any evidence. It's a faith without evidence, according to them. Now, Millard, they said they, Millard, face, Millard, tremendous difficulties. Now, Millard, today the issues have to be resolved. Issues raised by them. So far as we are concerned in this prolonged courier combat, neither we have been implemented as a party nor we have been given any chance, Millard, to file our objection.
You go and file.
No,
your
the
objection,
question is,
whatever
Millard,
you
issue
feel like.
resolved means, Millard, it indicates.
But they don't want resolution
No,
of this.
it is not a
That's
question
the
of
whole idea.
resolution.
They want
Millard,
us-
Just make an observation, sir, resolve to pass a decision in the matter.
No, sorry.
No.
Sorry, sir, I'm not accepting your prayer. Yes, call the next matter.
My lord, this order 1 rule 8 applications, my lord,
Yes.
that
order
should
one-
be allowed. Because why I am saying so?
Millard, order
because
1 rule 8.
There are other technicians, my lord.
Who are they? Where are these pleasing?
My lord, we are only
Why
the
are you
directors.
so aggrieved?
It is not a question of my
There
feelings.
will
Millard.
be
It is
published.
a question, Millard. No,
Will be
Millard.
published.
I am
an
not concerned with
advertisement.
Millard. The respondent number 5 will be responded by him. It's his senior, Mr. Majumdar.
Whoever
Now,
is there.
I am, Millard, so far we are concerned. Now, Millard, Millard, what are the issues? The issues raised by them.
Let the issues be decided by the authority. The court is not deciding anything. You go
Kindly,
over there,
Millard,
let
please,
us see.
kindly, Millard, observe.
Call the next matter.
Kindly record that your lordship has not got into the merits of the case. At
Has
least,
anything been recorded with regard to the merits?
no, resolved means, Millard, issues raised by him.
This is an erroneous interpretation.
Call the next matter.
Absolutely
please.
erroneous.
It is his perception which is frightfully narrow.
Don't take the writ court to that extent. Yes, 20.
No, 20 kindly take up tomorrow, my lord.
20. Somebody is mentioning something. Oh,
Your lordship called for a report. Report has been filed. It is ready for hearing. This is regarding the apartment ownership matter, where the appellate authority has permitted adjoining land to be part of the project and a form to be filled up to make it a part of the apartment owners association. That is under challenge. Report has been called for. I want to address your lordship not physically. You kindly take up tomorrow. I'll address your lordship.
Millard, there is a report. Millard, we are given liberty to use an exception to the report. Millard, my exception is ready. Millard, may I file it? Circulate হয়ে গেছে exception.
in that case, the matter is required to be heard. I'll place
Please
it in
request
the
Millard a hearing.
hearing. Otherwise,
Request a hearing.
The interim order may be the exception then, because otherwise they will not form the
Yes.
association by including the
come.
adjournment.
exception By the exception by whom?
By, my lord, the private respondent, my lord, the respondent number 4.
One private respondent?
Yes, my lord, the promoter.
Acha, exception by the private respondent.
Number 4.
Number 4. To the report submitted by the Special Commissioner, Housing Department. Is taken on record. Stop. The matter requires hearing. Stop. List the matter for hearing in the combined list of August. Stop. The interim order that is subsisting in the matter is extended till 26th September 2025 or until further order, whichever is earlier.
I'm for the added respondent.
Yes. Record your reference, and is any document to be filed by you? Yes.
So they're supporting, my lord,
The
the
point
of law now.
I was in RERA, that's why.
supporting this petition. Grateful to you.
Much obliged.
Same order as in 19. এটাকে না পুরো অর্ডারটা দেওয়ার দরকার নেই। সিপিএনটা নেই এখানে, এখানে হ্যাঁ সেম অর্ডার হবে, সিপিএনটা থাকবে না। রিটার্নেবল বললাম সেই দিনকে along with ওই আইটেম নাম্বার 19 সিপান এত WPA এত।
Lordship, in the similar matters are there, Lordship, should I give the name?
1 minute. 21, are you there?
No, Lordship.
Let it be called on. Otherwise the appearances go wrongly. In the last order, wrong appearances were recorded. Same order as 21. ঠিক আছে? Yes. Takun? 24. In which matter you are there? 23, 24. State, please give your appearance.
25.
Yes, appearance.
26.
Yes.
27,
my lord, I am happy.
28.
Which matter you are in?
29, Lordship.
All right. 29.
29.
Laid by Mr. Ghalib, Lordship.
30. 31. 32. Number 33.
This is my writ petition.
My lord, I am appearing on behalf of the state.
Earlier occasion, your lordship granted leave to add the, my lord, the authority concerned, is the appointed authority, and serve the copy. I served the copy, and after adding the concerned respondent, I served the copy. They have received the same.
Kindly give us a copy.
একই writ petitioner address.
Is anybody appearing for the central authority?
The 30th June, my lord, they have received. The affidavit of service was that. That is.
Who did you implead?
Yes.
Who did you implead?
I impleaded the, my lord, the district magistrate, the Ministry of Rural Development, as a 4. 5, the Ministry of Rural Development, Government of India, service through its secretary, having office at Kisi Bhavan, Dr. Rajendra Prasad Road, New Delhi, and also the secretary of the said ministry. It is the Monrega scheme. That's why your lordship given the direction.
Did you serve in the office of the Union of India here, 11 Strand Road?
My lord, I sent, my lord, before the authority concerned with a copy, my lord. They said that since you have already sent the copy. They have not received this.
They have not received.
So if your lordship, the particular advocates who are appearing before the
No, I do not know who appears always. You can get hold anybody from the central panel and see. Today nobody is appearing in. I'll just make it not today.
Yes, ma'am.
Tomorrow let us see what happens. Only not today.
That is your regulation also, ma'am.
You take it back.
My lord.
Not today. Oh, you are there. Who is your other side?
And for the petitioner,
Of the state, ma'am.
All right. Yes. What is?
let us state the district manager is supposed to file a report.
Yes. Let me see. Give a copy to him. Let him also see. What is the submission?
My lord had directed a report to be filed
Yes.
as to under what provisions these fees are being charged, my lord. Accordingly, this report has been handed over to me.
Yes. Bound in duty the same market function is to obtain answer from the officer from the legal other to be market adhikar. Who has given you this report?
My lord, it has come from the office of the district magistrate, my lord, but I find there is no signature.
Neither any signature, nothing
Yes.
stop. What is the veracity of this report? Who has prepared it?
It has come from the office of the district magistrate, my lord, of Postim.
That will not do. You have to show something.
Yes, my lord.
When will you come?
My lord gives me a week's time.
Again, week's time.
My lord,
Well,
it any time.
what about the cashew nuts? Are they there or it has?
That has been removed after getting some of fees, lordship. That I have the copy of
You've
that.
taken back the cashew nuts
Lordship.
and the vehicle in which the goods were transported?
Lordship, that was also released.
Released.
Cashew nut
All
was
right.
in.
So the immediate urgency in taking up the matter is no longer there.
No longer.
Very well. Please come.
Your lordship, kindly take up this matter on the next week.
Yes.
Otherwise, this will
Next
continue.
The learned advocate representing the state respondents produces a write-up before this court, which is neither signed nor dated by any authority. Stop. Let a proper report be placed before this court. The list. 14th of July, Monday.
I'm grateful.
You take proper instruction as to whether the goods in question will fall under the definition of this marketing produce or what.
It would be lordship. My application, Lord.
Yes.
No, this was taken
Who's
up.
your other side?
No, even on the last occasion, they had come and sought for an adjournment. Your lordship would recall
Who
this.
was there?
The auditor record.
Kollan Kumar Chakraborty. Has he come to court
There is a
today?
stay on their imposition of liquidated damages.
Has he come to court today?
Don't know, my lord.
In that case, I have to make it not today. I don't see him.
No, they could just file their affidavits and come back, you know.
What to be done? They have not come.
Because even on that day, he had taken time to take instruction.
Yes. I'll make it only not today.
But then you'll
Yes.
will make it not today and not tomorrow. Tomorrow also there's a lot of uncertainty.
What is happening tomorrow?
Tomorrow there is a resolution for no adverse order because of the strike that is there. There's a trade union strike. And Milord, may I just,
Not today and tomorrow listed niche likhe deben, not tomorrow.
Milord, may I prefer one thing?
Date ta diye deben.
Milord, may I just prefer one thing? Paragraph 3, your lordship had recorded till the next date of hearing, they'll not take any imposition of liquidated. This, I don't know if they'll construe as, it's just being made not today and not tomorrow.
if that could be extended till.
Difficulty is if any order is passed, then that has to be
This order is
signed.
anyways there, my lord. Your lordship had passed the order on 23rd of June.
Yes.
This can just be extended.
Actual জিনিস লিখে দিন তাহলে none appears on behalf of the respondents. Stop. Release the matter day after tomorrow. তারিখটা দিয়ে দেবেন. Stop. The interim order that is subsisting in the matter is extended till 15th July 2025 or until further order, whichever is earlier.
Very grateful. Forty-two, my lord, I am for the petitioner, my lord.
I am for the state response.
My prayer is very limited, my lord. I have filed and submitted an application representation. Kindly be directed, direct the authority to consider and pass it.
What is your prayer in the representation?
Prayer, my lord, the fact is, my lord, an LS.
Not the fact. What is your prayer?
That is necessary. Prayer is, my lord, a LS deed has been cancelled by the appropriate court. Cancelled and declared null and void. Thereafter, my lord, a partition suit has been, my lord, filed and a preliminary degree has been issued in respect of all the co-sharers. Now, my lord, my prayer is before the registering authority that kindly, my lord, the LS deed which have been registered before you, kindly either cancel it or kindly put such a remark so that if anyone get the certified copy, obtain certified copy or searching, they can be informed that the deed, the LS deed has already been cancelled by the appropriate court, so that no one can misuse the property. And my lord,
I have obtained an instruction, my lord, instruction from the registering authority. My lord, initially there is a two deeds. Number one deeds 1999, which was declared by the civil court as a null and void. My lord, second deed, rely upon that, the second deed which was passed, my lord, my specific instruction, the registered authority does not have any power to cancel any deed. My lord, it is the competent court who again has to again approach to the and ask for the cancellation for the next deed. My lord, individually the registering authority does not have the power to declare anything as a null and
civil court has cancelled only one deed.
One deed, initial deed,
Right.
1999. Rely upon thereupon there is another one deed.
kindly, my lord, record, I am praying for to cancel the 1990, the first deed, not second deed, because second deed has been, my lord, executed during the lease.
Where is the order of the court?
Order of civil court, my lord, starting from page 20.
Relevant portion
And
is
operative
page
portion is
59.
59. 59. May I read, my lord?
Wait. Same is decreed on deed of gift dated and immediately executed by the plaintiff.
13th April 1999.
And 1999.
Yes, that is I am praying.
And the
And my lord, pursuant to the same.
1 minute. Date of the decree is in 2006. This order was
Yes,
issued,
yes.
right?
Yes, the fruit of the order has been already, my lord, we get because a partition suit has been instituted and preliminary degree has been passed. Now, my lord, I have preferred an application, a representation before the authority. Pursuant to my representation, my lord, page 68, representation. Kindly turn to, my lord, page 73. The legal advisor referred the matter to the Register of Assurance, Kolkata, to take steps. Now, my lord, pursuant to the same, the respondent number 6, the additional sub-registrar asked us to submit the, my lord, certificate copy of the deed. We have submitted by our next letter at 76. Now, my lord, they kept themselves mum till date.
Please come.
My lord, this is my instruction, my lord.
The petitioner prays for a direction upon the registering authority to take necessary consequential steps steps in response to the direction passed by the learned court on 19th April 2006 in suit / case number TS 96/2000, page 20. Devashish Mojumdar versus Vishwajit Mojumdar, Sheila Pal, Debabrata Mojumdar and Kalpana Sarkar. Stop. The learned court was pleased to declare the deed of gift dated 13th April 1999, executed by Devashish Mojumdar, as invalid and null and void.
Executed by Vishwajit Mojumdar.
Allegedly executed by the plaintiff in favor of the defendant. It is mentioned.
As page 59.
Yes.
Pursued and the same may be decreed on contrary without cause, give allegedly plaintiff in favor of the defendant in respect to the suit property is declared to be null and void. It is declared that the defendant number 1, that is the my lord. Kindly see the my lord, page 20. Defendant number 1 is Vishwajit Mojumdar. The cost title did not acquire any right title interest in respect to the suit property by virtue of the said.
The learned court was pleased to declare the deed of gift dated 13 April 1999 executed by
1999 executed by Tuladin as invalid and null and void. The court declared that Vishwajit Mojumdar did not acquire any right, title and interest in respect of the suit property by virtue of the said deed of gift. Stop paragraph. The petitioner prays that the registering authority shall make necessary entries in its records so that certified copy of the said deed may not be used by third parties to take advantage of the same. Stop.
Point number 8. Only one paragraph has been dealt.
Acha. The instant writ petition is disposed of by directing the concerned registrar to take necessary consequential steps strictly in line with the order passed by the learned civil judge, cancelling the deed of gift. Stop. None should be allowed to take any benefit of the deed of gift which stood cancelled by the learned court. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Disposed. Instruction forwarded by the ADSR Kashipur Damdam, dated 8th July 2024, be written with the records.
Deeply obliged, my lord.
43. Who are you?
Madam, namaskar, madam.
Forty-three, my lord. I am appearing on behalf of respondent number 3, my lord.
The petitioner is not here. I'll make it not today only. All right.
But my lord, I have specific instruction, my lord, that the petitioner has died in the month of November 2024. On the last
23.
of
Let the advocate come. 23 he has died. How can the writ petition be affirmed in 24?
24, my lord. November 24.
November 24.
Yes,
This is affirmed in July.
May 24. Affirmed in May 20. May, June, July.
July 24. He died in November.
No.
All right. Let the learned advocate come. You have the death certificate.
No, my
Who are you?
I am the respondent number 3.
How are you related to the petitioner?
My lord, he was a member of our institute, my lord. I am for the society. He was a member.
And he is the member.
Yes.
All right. Come tomorrow. The learned advocate is not present today. Call the next matter. 44.
I am for the respondent, my lord. On last occasion, my lord, I'm sorry to mention one thing. On last occasion, my lord was pleased to direct to produce the policy matter of the numerical gradation. That issue has already been decided by the Supreme Court. I shall show your lordship that they have annexed the documents by Supreme Court order because numerical gradation is related.
Today, the petitioner is not here. I'll make it not today. This is the resolution of the Bar Association.
There tomorrow.
And a request for tomorrow also.
Because of the labor strikes, there are.
Tomorrow resolution, and I am not aware, but then for today I was.
It has been
sent.
Which,
But then I have not received it.
আর ধারণা প্রাক্তন সেক্রেটারি আছে বলুক না ও জানে তো এই ব্যাপারটা ভালো আছে ও তো করেছে এইসব তো তুই তো
Next. As and when it is taken up, it will retain its position in the list. As and when the petitioner comes, it will be taken up.
Item 44, Lordship, I am appearing online.
Yes.
Lordship, on the last occasion, there was a direction upon the Union of India to produce the. Yes, the Union of India was directed, Your Lordship, to produce a policy relating to the numerical gradings.
Numerical gradation.
On removal of the adverse ACR reporting.
Yes, madam.
Lordship, that was a date fixed if they have produced it or not.
Yes, ma'am. Right. So, my lord, I am at the initial say I have tendered apology. It is the numerical gradation is relating to the service matter, my lord. And in case any dispute of a service matter of an armed force personnel, my lord.
There is no dispute as on now. The direction was only to produce it. Where the petitioner is going to use it, that is his concern.
My lord.
It is not that the petitioner is raising any issue with regard to the numerical gradation. That is not the issue.
My lord.
He wants certain information.
What?
He wants certain information.
Yes.
Please bring that, and where he will use it is his.
That is sufficient.
The court is not interfering.
This is not the forum.
This is not the forum, and the court is not interfering.
Decide any dispute.
The court is not interfering. You please give one to the court and one to the petitioner. Yes. This is the numerical gradation.
Numerical assessment.
All right. The numerical gradation that has been placed in court today is today by the learned counsel representing the Union of India is taken on record. Stop. Let a copy of the same be served upon the learned advocate for the petitioner. Stop. Released for further consideration. Next week I'll place it.
Lordship.
Next Tuesday is 15th. Yes.
Lordship. I'm grateful, Your Lordship.
Call the next matter. Your other side? Venture spectacular. Other side is not here, only not today. And tomorrow, if it remains the same, it remains the same. Nothing can be done. But I am not getting relief. See, it's 4:15. I am still here. 46. Not today.
47.
Yes.
I am for the petitioner, my lord. Lordship, for the post of MMR at Moldarpur, my lord, Honorable Court pleased to direct to cancel the appointment and directed to start fresh recruitment, my lord. And the authority concerned, without holding any written test, interview, vivacy, straightway they gave appointment to private respondent, my lord. I have made RTI application. They said I cannot disclose the modus operandi, my lord. This is my case, my lord.
So what is, you still want information?
Lordship, page 58, my RTI application.
Prayer for information under the Act.
It does not defeat with provisions. They have not disclosed the mode of recruitment process, my lord. And Honorable Court pleased to direct. Page 51 is the elaborate order, my lord, in presence of learned AG, my lord. Page 51. In presence of officers of the authority. Again, same conduct done by this authority, my lord. Mr. Rajan Banerjee appeared for the private respondent. Then report be filed by the state, my lord.
From date. Recruitment process completed 3 months from date. And the steps where employment of the private respondent is terminated. And he should be allowed to participate in the fresh hearing with the petitioner. Who was the petitioner over here? You?
My lord. For Mollarpur. Not Mauritius. 2 posts are there, my lord. One for Mauritius, one for Mollarpur. Bifurcated. One.
There was a different matter. Can you remember?
Now I remember.
That was Mauritius.
Now, my lord, this
is the Mollarpur, my lord.
Now these two has been clubbed into one police station. So that's what, my lord.
Bifurcated, separate post created.
One. So the vacancy one has been given to someone else in terms of the order of this court. This
private respondent appointed for the post of Mollarpur. Wrong submission.
Why wrong submission? He has said
at the Mollarpur, this private respondent appointed.
The IGR and the other for initiation of recruitment process and afresh. Into police station shall be published at least 2 news. You, where is your junior? Where is the report?
Rajan Banerjee is appearing. I just
for private respondent, my lord.
No. He has some report.
These for the
private respondent cannot have report.
No, private respondent will not have the report. I'll make it not today. Come tomorrow, please.
Let them file a report, my lord.
They will file. They have something. I can remember Mauritius and.
Do not have a, these two are.
State has no report, my lord.
Let's file a report. Please come.
Lordship.
The matter relates to the recruitment process of MMR.
At Mollarpur, my lord.
At Mollarpur Police Station.
Lordship.
Stuff. The judgment dated 22nd September 2023 in WPA 15203 of 2018. Within bracket Mahirul Sheikh versus State of West Bengal and others, page 51. They can even. Is the order pursuant to which the selection process is required to be recruitment process is required to be conducted. Stuff. Learned advocate for the state respondents shall file a report before this court.
Yes.
22nd of July. Really.
Regarding selection process, my lord.
Yes.
Lordship.
22nd July. Yes.
Well, this matter I bring for only for not today.
Only not today.
So this
you also directed to produce the
rejection order.
Lying with my junior. She has
tomorrow, my lord, may I pray for this, my lord, because it pertains to my lord caste reservation certificate, my lord. Certain requirements are there for the petition. My lord, I mentioned this matter.
Certain?
My lord, it's required, my lord, for certain purpose. The daughter of the petitioner, father.
The request is made for only adjourning for the day. Tomorrow it will be there in the list.
It will retain its position, my lord, tomorrow.
It's a combined list. Where will it go?
My lord.
It will be there in the list in the same position.
I'm deeply obliged.
Next. Not today.
49.
Not today.
My lord, 49. I am appearing for the petitioner, advocate on record. Mr. Ajoy Devnath is engaged in.
Advocate on record is not Mr. Ajoy Devnath. Which matter?
Bhaskar Dotto.
Where is the matter? Where is the matter?
For this code number 14. Oh,
He is mistaken. 49 petitioner is neither the name that you are saying nor the. You should prepare yourself before appearing in court, right? You cannot appear impromptu. You are not that senior and you do not have that much of practice or experience that you will make submissions standing in front of court. Get yourself prepared and then make submission. Not today, hoye gache. Call next 50.
50, I'm for the petitioner.
Yes, please. Which one is yours?
54, 55.
Wait.
I'm waiting.
50. Yes. Your other side is not here. Not today? Next.
51, my lord. I'm appearing for the petition.
Not today.
I'm appearing for 5 days for number 5, man.
Not today. আর ডাকতে হবে না আর ডাকতে হবে না Your other side there?
No, my lord.
Then not
Day
today.
after tomorrow, because tomorrow is a strike, my lord.
I do not know. The court will be here. All right. You can join online. If your other side is there, it will be all right. Otherwise, it will
Yes, my lord.
go to the next.
I want to.
In person, somebody was mentioning. কি বলতে চাইছে?